Good afternoon. What's your name?
Yeah, Thomas.
All right, Ms. Thomas, you are charged with disorderly conduct. That's a city ordinance violation. And like it or not, it meets the criteria for probable cause, so I'll find probable cause that exists in this case. You do qualify for the public defender. Would you like for me to appoint them to represent you?
Yeah.
Okay, I'll go ahead and appoint the public defender, so.
And yes, Your Honor, there actually is an offer to resolve on this case. The state has offered an adjudication of guilt, credit for time served, and no return to where this happened, and court costs. I have had an opportunity to discuss that with Ms. Thomas. Last I heard, she'd like to accept that plea and enter a plea of no contest.
All right. Ms. Thomas, have you ever read one of those plea forms?
Yes, I have.
When you read it, did you understand what you were reading on it? Thank you, sir.
I've signed one before.
Yeah.
I know it.
So you think entering the plea based on that offer by the state to resolve it is in your best interest?
Yes.
Okay. Raise your right hand for me. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Well, I'll accept your plea. How about that? Now, you're going to be adjudicated guilty, sentenced to time served, which in your case is 2 days, ordered not to return. That's the off-ramp at I-4. And if I remember these facts correctly, located at Anderson Street off-ramp, so no return to that off-ramp except for legal and legitimate purposes.
Thank you, Your Honor. I was going to ask if there'd be an exception for driving or other reasons to be around there.
Yep. If it's legal or legit, she's okay, but otherwise, can't go up there. Now, I do have to impose court costs and the cost of prosecution and a fee for your attorney, which I'll do, but I'll have it reduced to a civil judgment. So, any questions?
Yes, sir.
Good luck.
Thank you.
Good luck.
You're welcome.
I'll be with this tonight, right?
Yep, you're going to be out.
How many days credit time, sir?
2,
Thank you.
or in keeping with the theme this afternoon, dose. Yeah, it's probably politically incorrect for me to say that. I pride myself on being politically incorrect. Okay, what's your name, sir?
Charles Wilberson.
Mr. Wilberson, you are, well, you're being held on a failure to appear.
And Your Honor, I know we usually don't do anything on the failures to appear, but if I may be heard on this one is a,
Okay, well, let me
Little
just
more
finish
clear.
telling him what I gotta tell him, okay?
okay.
Says you failed to appear for an arraignment on May the 23rd, grand theft third degree. That was in Division 12. That court issued a capias when you failed to appear and ordered that you be held no bond when you were picked up until that court ordered otherwise. You do qualify for the public defender, so I'll appoint the public defender to represent you. And so now, counsel, being all legally appointed and everything,
Yes, Your Honor.
tell me what you gotta tell me.
Yes, Your Honor. I know usually we don't disturb the no bonds on the failures to appear, but this one's a little different and more clear. If you look, he did not have an attorney at the time, and that's not really where this argument is going, but I'm just adding that. Where I'm going is the failure to appear was on May 23rd, 2023, and if you actually check, he was in Orange County Jail at the time. He was booked in on May 17th, 2023, and to my knowledge has not left since then.
Yeah.
Yeah.
I don't think under Florida law, with that second DCA opinion that's floating around, that I have the authority to modify it at all. You gotta get it done in division.
You're talking about Benoit?
Huh?
Benoit?
Well, I don't know the name of it, I just know it's.
Actually, that's the one that also states that you can't revoke bonds, correct? All of the judges have agreed, and there's an administrative order. This is how judges are allowed to revoke bonds now. All of the judges have agreed, and there's an administrative order that initial appearance judges can revoke bonds, which by virtue would mean that they can also modify. So if that's the argument, I feel like it's unfair to be able to revoke bonds but not fix
I think
bonds,
it's
if that
two
makes
different
sense.
things. Revoking because of a new criminal charge and modifying an existing bond or capias that's already assigned in a division. But, you know, I'll buy into your argument. Who is Division 12, by the way? Tell me what judge I'm gonna be making angry, so I know who to look out for.
Diego Madrigal.
Is he big guy?
I don't know.
Do you have any idea what size he is? You think I could take him?
Here, but
Who
yours,
is
you can look at
division?
the
Okay, we're good.
custody on.
Clerks informed me that I could probably take him if I had to. So, but you know, if this comes back to haunt me, I'm gonna come find you, counsel.
I understand, Your Honor. This one is just a little more clear on where he was located at the time.
Yeah, so he
Of
wasn't.
no fault of his own.
Confirm that?
I pulled it up for the state. If pretrial release, I think they have access to IMS, wants to confirm for the court.
No. If you confirmed, I'm good with that.
Yes, Your Honor.
You did? You're an officer of the court. If you tell me you confirm, that's
Yes,
the gospel.
yes, Your Honor. I pulled up the jail site and it shows he was in at 5/17/23.
Well, it's a grand theft charge, so what do you think would be a reasonable bond from? I don't know if he had a bond that was revoked.
He probably did. Your Honor, we would just. Your Honor, if the court was willing to do a $1,000 or $2,000 bond, we would be requesting that.
$2,000.
Thank you.
So you can get out, there is a bond, but you're gonna make your attorney and me look really bad if you don't show up for your next court appearance, you understand?
To be honest, Judge, like she said, I was in jail already, Busman.
Well, I understand, but theoretically, you're only in jail on this right now, right?
And I don't even know
He's
where this,
being held on something else. He's still here, yes.
I don't even know where this charge come from. I have no knowledge of this charge.
Well, but we're not here about that, we're just here about the failure to appear,
Yes, sir.
okay? So, yeah, I'll set a $2,000 bond.
Appreciate you.
Good luck.
I'll take that paper with you.
Thank you.
Your sentence, that's why.
Yeah.
That's why you're here. You've been given a sentence.
Have a good day, man. Appreciate it.
Good luck with everything. When your sentence is over, you can bond out. Make sure you call your attorney.
So, well, good afternoon. What's your name?
Amber Giles.
Ms. Giles, you're here because there's a capias that says you failed to appear for a status hearing in a case in Division 20.
Right, I had
And,
no idea about it. I had no recognition about it.
What?
I had no clue about a court date, whatnot. I was in Alabama.
Yeah.
Seeing my
That court was obviously disturbed when you didn't show up, and so the court issued a capias and ordered you held no bond, and put some words on the capias. They said, defendant is to remain in custody until evaluation has been completed. So some sort of evaluation has been ordered in that case, and apparently, that court, as soon as that evaluation is done, that court's ready to give you some, relief and maybe let you out of jail, okay?
what kind of evaluation you mean, sir?
I'm gonna guess it's a mental health evaluation,
Okay.
so.
More detail about it if they haven't already.
Okay. So where do I go from here, sir?
Well, back there,
You're gonna take this,
behind the wall,
talk to your attorney in more detail, and they're gonna.
that's what she's asking me, right?
You have, it's the public defender's been appointed, if not previously appointed, Your Honor. I think we're already on the case, yeah.
Yeah, they're already
your
in the
attorney
case.
Okay.
Okay, so you're gonna go that way.
Good luck to
I'll let them
you.
know that's the PD. I'll make sure they're aware you're here, okay?
Good morning, afternoon. How are you? You are who?
LaMargaret Hudson White.
Is it Hudson/White? Hudson
Maybe a hyphen.
hyphenated White? Okay. Well, you're charged with battery on an emergency medical care provider. You understand that charge?
I do, Your Honor.
Okay. It's a warrant that was issued, charging you with that, and actually it's a capias, goodness. And it has conditions. Let's see, it's got a bond, $2,500.
I'll pay 3,000, no, 2,500.
Says you're to have no contact directly or indirectly with any victim, co-defendants, or witnesses. You are to not return to the scene of the offense. You're not to possess, consume any alcohol or illegal drugs or controlled substances without a valid prescription. And you're not to possess any weapons or firearms in addition to the bond now.
Your
You
Honor.
understand all that, right?
Yes, Your Honor, I
Let
understood
me
everything
finish
you
real quick.
said.
You qualify for the public defender. Would you like for me to appoint them to represent you?
Yes, Your Honor.
I'll appoint the public defender right there, okay? So if you have any questions today, you can ask your attorney.
She actually cleared them all up earlier.
Did she?
She's
She's
great.
pretty good at that, isn't she?
Yeah.
Yeah, we all like
We
her
have a
around
bond
here.
going on.
Okay, well,
Honor-
good luck to you.
Your
young
Honor,
lady.
I apologize. I just want to make sure, looking out still, this happened at a hospital. We would just ask that she be allowed to return for medical purposes and emergencies.
I don't know if they've trespassed her or not.
Uh-oh, which hospital? Orlando Health or Advent Health?
You
Well-
don't have to respond to
Oh,
this,
I'm
okay?
sorry, I didn't know.
No,
It's
no, you're
Orlando
fine.
Regional.
This one's at Orlando Regional Medical Center, ORMC.
Okay, well, I'm not gonna tell you you can go back there, other than for legitimate purposes. But if you're trespassed from there and you show up, you're coming back here, you know that, right? So are you telling me you don't think you're trespassed?
I think I'll stick with Advent Health with my United Healthcare Optum, and I'll never see ORMC again.
There you go.
There you go.
Good solution.
Good solution.
Thank you very much.
Thank you so much, Your Honor, and Advent Health to you.
Good luck with everything.
Oh, well. So, let me see now. What's your name, ma'am?
Pamela Jade Sears?
Sears is your last name?
Yes,
Like the store?
like the store that went bankrupt.
Yeah, they did go bankrupt, didn't they?
Yes.
I got a funny Sears story, but if I
many
tell you,
others.
everybody's gonna get angry at me because it'll take time. So, you're charged with trespass on property after warning?
Yeah, they never gave me a slip.
And you
So
don't,
I didn't think it was paper warning. It was a different one.
Okay.
So I don't know if I'm trespassed from all of them.
Well, that's not the most serious thing you hear about, because
Well, I mean, if I have an account there, I
Yeah.
don't understand.
yeah, you are trespassed from that location, so apparently if you're gonna use your account, you have to do it online.
Oh, I can't go to any of them.
Do you know what online means?
No, I don't have that access.
Okay. Well, you'll have to go to another location, because I think you're only trespassed from that one store,
Okay,
okay? But I don't know for sure. You need to check that out, okay?
And-
all right.
And you're also charged with battery on a law enforcement officer.
No,
And
I
don't-
thought he
you
was
don't-
gonna punch me in the nose. I
You
lifted
don't-
my arm, and he thought I was gonna hit him.
Okay.
I started laughing.
And then you're also charged with resisting with violence. So those are some pretty serious
Okay.
charges. Let's do this. The trespass on property after, and by the way, you do qualify for the public defender.
Yep.
So I'll appoint them to represent you in the case. The trespass on property after warning, we'll set that bond at $100. The battery on a law enforcement officer, that's really the big one right there. But what I'll do is I'll set a bond on that one at $150. And then you got resisting with violence, I'll stay that bond at $1,000. So you can't go back to that store, right?
Well, I talked to him coming in, and I said, you better let me know which one I can go to. If I can't go to anyone, I'll cancel the account.
Okay,
He said he'd let me know.
well,
The same office.
yeah, if you have anything else you want to say or questions,
No, not
wanna-
at all.
you want to talk to your attorney right there, okay?
Okay.
So if you bond out, give us a call. We'll be in touch with you as well too, but we don't have your phone number from today, so you're gonna
I don't
to
have
call us.
any contact
So maybe come and see us.
through mail or phone, but, just let me know if there's no Amscot I can go to. I'm not online, I'll cancel account.
And your attorney will talk to you about that, all of that in more
Oh, I
detail,
thought
okay?
you were gonna be,
I'm your attorney for today. You're gonna have one who's assigned to your case. who's
okay, so
follow
they're
you
gonna
the
give
rest
me
of the
about
way.
30 days for this.
It all just depends, because
He's not gonna tell me?
we're not gonna resolve it today. But
All
that's
right.
it for today. But your
All
attorney
right.
will explain everything more.
Okay, thank you, Judge.
You're welcome. Good luck. Is that a real hair?
No, yeah.
You were saying earlier, is that her real hair? That's actually her hair.
Is that her who? No, Your Honor.
Oh, that is?
Oh, we're on the record. It's a very eccentric, hairdo she has, Your Honor.
It's a tiny bit noticeable.
It's, yeah, you had to really like dwell.
It shocked me for a few seconds.
If you saw
I didn't know what to say. I was determined not to say anything because, you know, whatever I said, it was gonna be wrong.
very,
So, better part of discretion. Step up there, sir.
Your Honor. We have Charles Luke,
Okay.
medical status right now.
All right, Charles Luke, medical status, so,
And Your Honor, he does have an offer to resolve if we can reset to tomorrow. It's a credit time served offer.
yeah, well, tomorrow's Saturday. I don't know if the weekend judge will be inclined to do what you need to have done, but yeah, I'll be happy to do that.
Thank you, Your Honor. We'll give it a try and see what happens.
All right. Any idea who's gonna be here tomorrow?
Tomorrow it is, I can tell you. Just so that you know. It's an Osceola Judge, Darenthal,
What is it? How's it spelled?
Derenthal. I think it's a new judge.
You
It's
know,
a
I don't wanna
circuit
say I've never
judge.
heard of him before, but,
Judge Darenthal.
well, we'll have to see how that goes tomorrow. And, what's your name, sir?
Coleman, James, Jr.
James Coleman. Mr. Coleman, you are charged with trespass on property after warning. Do you understand that charge?
Yes, sir.
Okay,
Um,
yeah, what are we talking about here? We're talking about
I was having a
100
beer
East
at-
Center Boulevard, the Stagger Inn. I don't know where that's at. But, okay, so counsel, you got something,
Your Honor, there is an offer. We haven't had an opportunity to discuss it. The offer from the state is an adjudication of guilt, credit for time served, no return in court costs. I didn't see that he was found incompetent to proceed in an older case. I know competency is ever-changing, but that was a concern of mine. But the offer is an adjudication of guilt, credit for time served, no return in court costs.
so Mr. Coleman, do you understand the offer the state is making to resolve the case
Yes.
today?
Yes, I do.
What do
Clear.
you think? Is that something you want to consider?
Correct. Yes,
So you think maybe you might like to enter a plea and get it over with today?
correct. Yes.
Okay. You know that part of it is you don't get to go back to the Stagger Inn.
That's fine.
Okay,
Dandy.
all right. Well, we got a plea form there. I bet you've seen one or two of those in your day.
Certainly.
So, you sign that plea form and you're out of here.
Okey-dokey. Yeah, ooga mooga too.
The Stagger Inn, 100 East Central. You familiar with that?
They're gonna give you a pen to sign, and I'm just double checking one.
Here,
100 East Central.
right here.
Trying to picture that, I can't. Cannot picture that. So how about it? You familiar with the Stagger Inn? Okay. Well, and I think you have a date.
I think, Your Honor, it's over by the library.
Is it
Yes.
right down there?
Just because I walk downtown all the time, I know.
I should have asked you if you were familiar with it. So, Mr. Coleman, would you raise your right hand for me? Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Now, you indicated you're familiar with these plea forms?
Yes.
So you understand what they say?
Yes.
And you believe today it's in your best interest to resolve this case?
Yes.
Okay. And so you're entering a plea of no contest to the charge, is that correct?
Correct.
All right, well, I'll accept your plea, adjudicate you guilty of the charge, sentence you to time served, which is 2 days, Order that you not return to the Stagger Inn, 100 East Central Boulevard. Because if you do, apparently you're gonna run into some of us down there. And then there's court costs and the cost of prosecution and attorney fee, all of which I'll have reduced to a civil judgment, okay?
I'm gonna suspend your driver's license if you don't pay it.
So good luck, Mr. Coleman.
Thank you.
You're welcome.
Good luck with everything, okay?
So, thank you.
Your Honor, for the,
Did y'all feed them funny Kool-Aid back there today or what? Because everybody's in such a great mood.
Full moon last night, Your Honor. I do believe it.
Your Honor, for the next case, I have a PC argument just for the second violation portion of the,
All right, step right up there, ma'am. What's your name?
Hello, my name is Catherine Contreras.
Ms. Contreras, you are charged with entering or remaining in a place for prostitution or lewdness as a second violation. And then there's a separate charge of prostitution or lewdness as a first violation. Do you understand the charges?
Not really.
Okay, what don't you understand?
Can you explain them a little bit? I understand the first violation.
Well, yeah, okay, so you got the first one. The second one,
the second is a whole separate one. It's entering or remaining in a place for,
Okay.
so it's a separate, and that's why I'm saying the PC argument is that there's nothing to indicate that's her second violation for that. That's a separate charge.
okay, so the
Okay.
second, count 2 is charged as a first violation. Count 1 is charged as a second violation.
Your Honor, they're different. One is the charge of prostitution. The other one is the charge of entering or remaining in a place for prostitution. So they're different. So I'm saying you can't use the first one to be a second, if that makes sense.
Okay, I'll treat it as a first one. How about that?
Yes, that was all defense was requesting. Thank you.
Okay, we'll just treat it all as a first offense. Well, you know, without getting real graphic, I don't think I can describe it to you. They're both prostitution-related charges,
Okay. Okay.
which, you know, your attorney might be able to give you a better explanation than I can. You do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes.
Okay, I'll do that. Now, you have bonds on both of them. Count 1 has a bond of $750. Count 2 has a bond of $100. So you can get out of jail by posting the bonds.
Okay.
And and I doubt very seriously if there's a plea offer on this case. Am I
No, Your
correct?
Honor. There's no offer on this one.
Okay.
But there may be one. We do have diversion programs.
And yes, there will be an offer likely at some point.
Yep, it's just not, there's no offer today to resolve it, okay?
Okay.
So, any questions you have, you want to direct them to your
Didn't know if
attorney
you
there?
Resolve hers right now.
Good luck.
Thank you.
Take this with you. That's your bond, and then this is just the police report. I had it for my argument today, so you can take it with you, okay? Two separate charges. That's the confusion. One is the actual place, and one is the action, like whether it's completed or not. Yeah. Okay. Yeah.
Good afternoon, sir. What's your name?
Maria King Fields. Good afternoon.
All right, Mr. Fields, you are charged with trespass in a structure. Do you understand that charge?
No.
You don't understand the words?
Can you explain it?
Yeah, trespass in a structure. Let's see, where were you at here? It's the Rosemont Specialty Pharmacy. You were told to leave a trespass previously, and you went back there according to the affidavit, which does form up probable cause for the charge. So, do you understand what it is now?
Yeah, I understand.
Okay, well, I do find probable cause for that. Now, you do qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, sir.
All right, I'll do that. Counsel?
Your Honor, there is an offer in this case. However, he is currently being evaluated and going through competency in his other pending case. For that reason, we would just ask that you stay the bond and that you take no action on the out on bond as he's being evaluated.
All right. let's see, the bond is $500, sir. You're ordered not to return in the event that you make bond to the pharmacy over there in Rosemont. And, yeah, I'll take no action on the out on bond case.
Well, I don't want to
then-
go to trial, so
And-
I'm pleading guilty.
You can talk to your attorney in more detail about your options.
So
okay?
you're not the attorney?
I'm one of your attorneys, but you can talk to the attorney who's assigned. Put you back on okay? Take this with you.
Hand out your clothes.
Yeah. No return. Yes, ma'am.
Morning.
See what I got here. Okay, good afternoon. What's your name?
Good afternoon, Your Honor. Joyce Garcia.
Ms. Garcia, you are charged with battery. Now, it's charged as a misdemeanor battery. I did review the affidavit. I do find probable cause for the charge. And you do qualify for the public defender, so I'll appoint them to represent you. Your bond is $500. In addition to the bond, you're going to be ordered to have no contact with the victim or any witnesses in the case as a condition of release. Do you understand?
I don't know that person, so I don't really care about seeing that person.
I can't understand what you're saying.
I don't know that person, but I would like to get a restraining order because I felt followed. So if I feel followed, that's why I did what I did.
Your Honor, it appears she understands and she's fine with it.
I would like to get a restraining order against that person
She
that
doesn't
was.
wish to have contact with them herself,
Right.
is what she's saying.
I want them to stay away from me, not me stay away from them.
Well, it's a two-way street. You stay away from them, and
I
then
don't know who they are.
naturally they'll stay away from you.
They need to stop following me.
Good luck.
Take this with you. Good luck with everything.
Thank you.
You're welcome. Wow. All right. The Kool-Aid cup overfloweth.
Yes, Your Honor.
Good afternoon, sir. What's your name? Henson? All right, Mr. Henson, you're charged with trespass on property after warning. Do you understand what you're charged with? Okay. I did review the charging affidavit. I do find probable cause for the charge. Let's see, we're talking about the social club here. I also see that you qualify for the services of the public defender. Would you like them to be appointed to be your attorney?
Are we resolving the case?
He's just going through everything, and then yes.
So you do want them appointed. I'll appoint the public defender to represent you.
Thank you.
Counsel?
Yes, Your Honor. The state has made an offer today. I've discussed the offer with him. He does wish to accept it. It's an adjudication of guilt, credit for time served, no return in court costs. He'd like to enter a plea of no contest. And no.
Thank you, ma'am. All right, Mr. Henson, you ever read one of these plea forms?
Yes.
And when you read it, did you understand it?
Yes.
Okay. Would you raise your right hand for me? Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Sure.
All right. According to the plea form, you're entering a plea of no contest to the trespass charge. Is that correct?
Yes, sir.
All right, sir. I'll accept your plea. You'll be adjudicated guilty of the charge, sentenced to time served, which is 2 days, ordered not to return to the social club at 54 North Orange Avenue as a condition of the sentence. You'll be ordered to pay court costs, cost of prosecution, and a fee for your attorney, all of which I'll have reduced to a civil judgment, sir. All right? Good luck.
next on the docket was Hudson Reynolds, Kiana. She's on mental health status.
Okay,
Your Honor, there is an offer to resolve this one with credit time served if we can reset for tomorrow.
so let's reset that one for tomorrow. And I'll stay the bond amount in the amount of $500. I'll also indicate that I did find probable cause and is being reset for a plea. Now, good afternoon. What's your name?
Lenore Lanham.
You have Janaya Jones, Your Honor?
Yeah, I do.
She was pretrial release administrative.
Okay, PTR. There you go. All right, Mr. Lanham.
Sir.
You are charged, sir, with the offense of battery. In your case, the charge is a misdemeanor of the first degree. Do you understand that charge? And, well, I don't see an affidavit of insolvency in here. I don't have an affidavit of insolvency, so I can't see whether you qualify for the public defender or not. Do you have any kind of income source, sir?
I was gonna represent myself.
You were? You sure? Well, have you ever done that before? Represented yourself?
No, I haven't.
No? You understand that there are certain things I gotta tell you when you tell me you're gonna represent yourself, I gotta talk to you about. Specifically that because you're charged with a criminal offense, you have the absolute right to have an attorney, even if you can't afford one. I can appoint one to represent you. That way you got a trained legal mind in the courtroom with you at all times to make sure that you don't slip up and say something that's gonna hurt you or do something that, you know, might cause you to be worse in the case.
I'll take you up, I'll do a public defender.
You'll take them? Okay. So I'll go ahead and appoint the public defender for you. Now, on the battery case, I do find probable cause, and your bond is $500. Now, you're gonna be ordered to have no contact with any victim or witness in the case.
Sir.
No weapons on or about your person as a condition of release, okay? All right.
Your Honor, this does appear to be a roommate situation. We would request a one-time return with law enforcement to retrieve belongings.
Okay, well, sure. Let him go back one time with law enforcement to pick up his personal property. Otherwise, no return to the scene of the offense. Good luck.
Thank you.
Step right up, ma'am. What is your name?
Zena Malave.
Okay, Ms. Malabe, you're before the court charged with prostitution or lewdness and entering or remaining in a place for prostitution or lewdness. Do you understand those charges?
Yes.
Okay, and looks like you qualify for the public defender. Would you like for me to appoint the public defender for you?
Sure. Yes.
Okay, I'll appoint the public defender to represent you. I did review the charging affidavit. I do find probable cause for the charges. And I'm looking, well, I see what it is. She's got an out-of-state address, so your bonds are gonna be set at $1,500 on count one, $200 as to count two. And you're not to return to the, there's the Marriott, I think.
Your Honor, she does qualify for pretrial release.
She does? Oh, yeah, she does, okay. Well, so yeah, I'll authorize you to be released pretrial release. There are rules with pretrial release that are gonna be explained to you. And those rules are fairly comprehensive. So you wanna pay attention to that, okay? But, sure, okay, but still, I'm gonna keep the order in place that she cannot return to the Marriott Courtyard at 8600 Austrian Court. And, so do you understand what I'm saying?
Yes.
Any questions you have, direct them to your attorney.
And Your Honor, if we can also have permission for her to return home as this case is pending. It said she had an out-of-state address, so I just wanted to make sure if she is out of state, she can return home.
Delaware? Delaware. Yeah, okay. I'm not restricting her travel in any way.
That's all I wanted to check.
Pretrial release may have something to say about that, but I don't mind.
I don't, do they monitor out of state for pretrial release? They do.
Yeah, I don't think she'd qualify for it if they didn't monitor them out of state. They didn't used to. You and I remember when they didn't. But nowadays, apparently, out of state is okay.
You have any questions? Okay.
He's in the what? He's in the felonies. Yeah, we'll wait till he comes in.
And is that all, Your Honor? I just want to make.
That'll do it.
All right. Stay in touch with us if you do travel back. We can keep you informed of court dates and you don't miss any, okay?
Okay, I have a Nicole Rebecca Quinty.
Bonded, Your Honor.
Did? She bonded. Okay. We need more of that. All right, sir, step right up there.
One more, Christian Santiago,
Uh-huh.
the mental health status.
Okay, mental health, that's probably
Actually, Your Honor, I apologize, my apologies. He's on behavior status, Your Honor.
behavior status.
Your Honor, if we can roll it to tomorrow and give it one more shot. It is a credit time served offer. No?
Okay,
Okay.
all right.
Well, they're not. No.
It's reset for tomorrow for a plea. It's a shame Judge Clark is not working tomorrow. Pay her back for all those ones she gave me back on Wednesday, huh? All right, sir, what's your name? All right, Mr. Rodriguez, you are charged with petty theft, which in your case is charged as a misdemeanor of the first degree. Do you understand what you're charged with? No, you don't understand the words or what?
On the time when you get up from the store with the merchandise that you get.
Okay.
But I didn't get up from the store.
So you don't understand why you got charged, but you understand that you're charged with theft. Is that correct? Pardon me?
No,
No what?
I don't understand.
You don't know what theft means? Stealing, taking something that doesn't belong to you.
Don't talk about it.
You understand that?
Yes.
Use your adult voice, sir. Don't nod your head at me. So, do you understand? You're making life a whole lot more complicated for yourself right now.
My first language is Spanish, you know. And,
Your Honor, it seems like he's indicating he needs the Spanish interpreter as that's his first language.
Okay, we might as well. We've got a felony case that's gonna need an interpreter too, apparently. So if I'm gonna call the interpreter again, why don't we dig the felony case out from back there and bring them out so I can do them both at the same time?
Garcia and Fonseca.
Which one's the other
It's
felony?
John David Garcia and Fonseca.
Garcia? Oh, Garcian, Johan,
Johan, sorry.
or Johan, I said it wrong.
And let's see.
Good afternoon, Your Honor. This is Laura Bretaña, certified Spanish interpreter, previously sworn.
Ah, well, welcome back. Sorry, we found some more. I bet we interrupted your afternoon coffee break too, didn't we?
No, thank
No?
No.
Okay, so, go ahead and tell me your name, sir. Wait for the interpreter to do her job. You wanted her, now she's here, let her do her job.
Luis Gaspar Villalona Rodríguez.
Luis Gaspar Villarona Rodríguez.
All right. Mr. Rodriguez, you are charged with the criminal offense of petty theft. Do you understand that charge?
Sí, entiendo.
Yes, I understand.
And let me just say, I've read the affidavit. I do find probable cause for the charge. I don't see an affidavit of insolvency here. Did you intend to talk to a private attorney about the case?
No.
Are you representing yourself, sir?
No, necesito uno, pero que no, yo no estoy desempleado, no puedo costear uno.
I need one, but you see, I'm unemployed, so I cannot pay for it.
Okay. I'm going to appoint the PD just for today's purposes. Okay? And we'll let him fill out an affidavit later on and see if he qualifies. So for today, he has the public defender representing him. Now, the bond is $500, sir, and you are ordered not to return to 5924 South Orange Blossom Trail, which is the Advanced Auto Store, as a condition of your release, should and if you make bond. Do you understand?
Sí, entiendo.
Yes, I understand.
All right. Thank you, sir.
Gano del...
Surly guy, wouldn't he? What's the name of this next one that's coming up? I got one more for you, Madam Interpreter, and then I'll let you get back to that coffee break. There we go. Thank you, ma'am. Okay, and I forgot to give her a case number on that one. What is the case number on that? Madam Interpreter, the case number on that one we just did with that very happy surly gentleman there was 2023 MM 5162AO. The next one is 2022 CF 5184AO.
I did see that, but it looks like they may have filed a motion to withdraw. Sorry, I overheard you.
Has it been granted?
I don't know if it has been granted. I think it, after the failure to appear, the case went on hold.
All right, sir, tell me your name.
Johan David Garcia Fonseca.
Johan David Garcia Fonseca.
Okay, Mr. Fonseca, you're being held as a result of a capias being issued when you failed to appear for a trial management conference on July 5th of this year. Do you understand that?
Sí, sí, señor. Lo que pasa es que no...
Yes, yes, sir.
Okay. Now, that court ordered you held no bond pending further order of the court in Division 16. Do you understand?
No, señor. Por ahí, ¿cuánto tiempo me toca estar más en prisión y no me pueden dar una fianza?
No, sir. How much time, how much longer do I have to be in jail? And can you give me a bond?
Well, you'll be in jail until a court in Division 16 sets a bond for you or releases you in some other way. I can't predict how long you'll be in jail. Now, I want to talk about an attorney with you. Apparently, you had a private attorney in this case before, is that correct?
Sí, pero ya él no me va a volver a asistir, necesito un abogado público.
Yes, but he's no longer going to help me. I need a public defender.
Okay, then I'll go ahead and appoint the public defender for you. And so any questions you have at this point, you want to direct to your attorney. That's her standing right next to you.
Just generally speaking, so he's aware, as I need the interpreter to speak with him. Usually, failures to appear are not modified at initial appearance as it was issued by another judge. So right now, he's being held no bond. However, he will have an attorney who is officially assigned to this case, and he can contact them and talk to them about filing a bond motion to adjust this. And I'm handing him that paper with that phone number.
Ah, ok, o sea que hoy mismo no me pueden dar una fianza, ¿no?
So then I won't be getting a bond today, right?
Right.
Ok, entonces me tengo que comunicar con el abogado y él me dirá si me dan fianza o cuánto tiempo voy a estar aquí, ¿correcto?
And then I have to get in contact with the attorney, and he or her will tell me how long am I going to be here and if they're giving me a bond or not, right?
Part of it, yeah. I don't know that the attorney won't contact you at some point in the future, and then you can talk to your attorney about those things.
Ah, ok, vale. Muchas gracias.
Okay, thank you very much.
And you're very welcome, sir. And Madam Interpreter, thank you very much.
Thank you, Your Honor.
Bye.
Bye.
What's your name, sir? Mr. Wilson, looks like you've got an out-of-county hold for Lake County. I'll just tell you that as sort of informational stuff, you know, it happens to be on my form here. Now, for here today, you're charged with trespass on property after warning. Do you understand that charge?
Yes, sir.
Okay, well, let's see. Trying to see the place, yeah. There is probable cause for the charge, and looks like you qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes, sir.
Okay. All right, I'll appoint the public defender. Now, counsel?
Yes, Your Honor. I previously spoke with Mr. Wilson in the back. I explained the offer to him. The state has made an offer of adjudication of guilt, credit for time served, no return. At the time of discussing the offer, he said he wished to enter a plea of no contest and accept that offer. I did not inform him of the Lake County hold at the time, but he is now aware.
All right, so Mr. Wilson, raise your right hand. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Well, you're entering a plea of no contest to a trespass charge. You understand?
Yes, sir.
And do you believe it's in your best interest to do that? Yes?
Yes, sir.
Okay. And you ever read one of these plea forms?
Yes, sir.
And you understand what it says?
Yes, sir.
All right, I'll accept your plea, adjudicate you guilty of the charge, sentence you to time served, which is 2 days. Order that you not return as a condition of your sentence to 5413 Vanderlyn Street, Orlando.
Yes, sir.
Also, I'll assess court costs, cost of prosecution, attorney's fee, all of which will be reduced to a civil judgment.
Yes, sir.
Good luck.
Thank you.
You're welcome.
Everything in Lake County, too.
Afternoon, sir. What's your name?
Luxon Calistin.
All right, Mr. Calliston. You're being held on a failure to appear capias on a petty theft charge, Says you failed to appear for a status hearing on June 26th. And that court issued the capias and set your bond at $2,000. Now, did you have an attorney in that case?
Yes.
Yes? Was it a public defender?
Yes.
Okay, well, that's who's still representing you. So, if you have any questions, you can ask the attorney before you leave today. She's right there.
There's no offer right now. You have a bond though, a $2,000 bond, okay? So you'll be able to talk to your attorney in more detail.
But I can't get bond out today.
You can bond out today.
Good luck, sir. Good afternoon, sir. What's your name?
God bless you, Your Honor.
Thank you.
You're welcome.
And your
Willie
name?
James Flores.
Willie Flores?
Yes, sir.
Okay. Mr. Flores, you're charged with disorderly conduct. That's a city ordinance violation.
Yes, sir.
Misdemeanor of the second degree, by the way. Huh? I thought he said his name was Willie Flores. I'm pretty sure that's what he said. That was the one before.
Willie Flores.
Yeah. And looks like you qualify for the public defender, so I'll appoint them to represent you, sir.
Yes, sir.
Thank you, ma'am. All right, Mr. Flores, raise your right hand for me. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir. I do.
All right. Now, you're entering a plea of no contest to a disorderly conduct charge.
Yes, sir.
Understand? And do you believe it's in your best interest to do that?
Yes, sir.
Okay. Have you ever read one of these plea forms?
Yes, sir.
Feel like you understand what it says? All right, sir, I'll accept your plea of no contest. You'll be adjudicated guilty of the charge, sentenced to time served, which is 2 days, ordered not to return to the area of, under Interstate 4 at West South Street in Huey.
Yes,
For
sir.
any illegal or immoral purposes.
Yes, sir.
I'm also assessing court cost of prosecution, as well as an attorney's fee, and all of that will be reduced to a civil judgment. No action on the one he's out on bond on.
Yes, sir. Thank you, officer.
Good luck to you.
I mean, Your Honor.
You still have this case, okay? So just make sure you stay in touch with your attorney. You're still out on one is what I'm saying.
I go to 27.
Amazing. I'm happy you know that. Good, good, good.
Thank you.
Good luck with
You
everything.
ran a sting yesterday on disorderly conduct, huh? Good afternoon, sir. Afternoon,
Hill.
sir.
Edward,
Tell me your name.
Edward Russell Hill.
All right, Mr. Hill, you're charged with disorderly conduct. Do you understand that charge?
Yes, I do.
All right. And I'll just appoint the public defender for you.
Say again?
Now, I see you've signed a plea form there. Does that mean you want to resolve this today?
Yes, I do.
Okay. Oh, yeah, you did. Okay. So would you raise your right hand for me? Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
I swear.
All right, you can put your hand down, sir. So, do you believe it's in your best interest to enter a plea of no contest today?
Yes, I do.
Okay, and have you ever read one of these plea forms? The thing you just signed, have you ever read one of those?
Yes, I do.
Okay, and when you read it, did you understand
Yes.
what it said? All right. Then I will accept your plea, adjudicate you guilty of the charge, sentence you to time served, which is 2 days. Order that you not return to the area of East Anderson Street and Magnolia Avenue for any illegal or immoral purposes. Also, assess court costs, cost of prosecution, and an attorney's fee, and I'll have that reduced to a civil judgment.
Yes.
All right? Good luck, sir.
Thank you.
You're welcome. Good afternoon, sir. What's your name?
Oh, John Walter.
All right. Mr. Welter, you are charged with disorderly conduct. Do you understand that charge?
Yes, sir.
And says city ordinance violation. Mm-hmm. Okay, Anderson Street off ramp, yeah, all right. And it looks like you qualify for the public defender. Would you like to have me appoint the public defender for you?
Yes, sir.
All right, I'll do that at this time. And also, I've been handed a plea form indicating that you wish to enter a plea of no contest to the charge.
Yes, sir.
All right, raise your right hand, sir. Do you swear or affirm the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. So, have you ever read one of these plea forms?
Yes, sir.
You understand what it means?
Yes, sir.
Any questions about it?
No, sir.
You believe it's in your best interest to enter the plea today?
Yes, sir.
Okay. I'll accept your plea, adjudicate you guilty of the charge, sentence you to time served. Order that you not return to the off-ramp at, from I-4 on Anderson Street for any illegal or immoral purposes.
Okay.
And also, I'll assess court costs, cost of prosecution, and a attorney's fee. I'll have all that reduced to a civil judgment, sir.
All right, thank you.
You're welcome. Good luck.
Out on bond cases, Your Honor?
Yeah, no action on the out-on bonds. Let's see. White, how about Gianni P. Cuato? C-U-T-T-O?
You have a booking number, Your Honor?
A booking number, I got an inmate number, 23019-160.
Posted bond, Your Honor.
Ah, bonded. And, who the heck is that? Deborah Kyle Hadner?
Down on our docket, Your Honor.
Okay. I bet she bonded too. Her inmate number is 23019-167.
Yeah, posted bond, Your Honor.
Bonded, got it. You said white bonded, right? Okay. Well. Okay, yes, sir. Step right up there. Andrews refused, okay. Possession of cocaine, well, counsel, it looks almost like your office represents this person in a couple other cases. Are these names familiar? Choli Zubkin?
Chloe?
Chloe Zubkin.
Chloe Zubkin, yes, yes, yes.
So she's PD?
Yes, she is.
So, yeah, it looks like your office has them on a couple other cases. We got Mr. Andrews refusing to come up. I think I know why, because he didn't want to hear the bad news. But,
We're fine with, if you appoint us to his new case, we're fine with waiving his appearance.
okay, well, his charge is possession of cocaine, which there is probable cause for. And then he's got a failure to appear on a felony. No, that's somebody different, excuse me. No, it's him.
No, I think
It
he
is
does.
him, okay. On the cocaine charge, I'll stay his bond at $1,000, and then on the failure to appear, that's no bond. Says he failed to appear for a plea hearing on 7/13/23. Let me look at the case number on that. That's 13804. There's that. Okay. And he's out on bond on two fairly serious felony matters. So I'm going to revoke both those bonds and order him held no bond pending further order of the court in each of those divisions, which is 22 and 14. So there you go. And stay as bond at $1,000 on the cocaine charge and no bond on the failure to appear. All right, your name, sir?
Damian Austin.
Mr. Austin, you are charged with possession of heroin, possession of drug paraphernalia with intent to sell. I think that's probably a typo.
Your Honor, I do have a PC argument on this one.
Okay. Sale and delivery of cocaine, possession of cannabis, less than 20 grams, resisting without violence, and then a separate affidavit, just to add a little pain to the whole thing, the charge with having an open container of alcohol. So, counsel.
Yes, Your Honor. Count 2 is possession of drug paraphernalia with intent to sell. I don't even know if there is even mention of drug paraphernalia. I understand that baggies can be considered such, but in reviewing the statute, which I can pull back up, I thought I had printed it out, it didn't seem like probable cause was met for that. Additionally, for the sale and delivery of cocaine, we would argue that there's not enough probable cause for the sale and delivery portion. We would argue that it is a simple possession of cocaine. The only thing they rely on for the cocaine is the amount. I don't believe there's any additional information.
Well, they're talking about the amount of cocaine being separated among different baggies, 5 different baggies. That's probably where they came up with the idea. I agree with you on the drug paraphernalia as far as the part of it that says with intent to sell. That seems, whenever I see that, I just have to laugh when I see it. Today, I'm not laughing, of course. But I do find probable cause for them, so. As to the heroin charge, let's see what we got here. Well, let's start with the sale and delivery of cocaine, which I'm finding probable cause for. That bond is $7,500. The possession of heroin, I'll set the bond at $150. The possession of drug paraphernalia at $100. Possession of cannabis, also $100. Resisting without violence, also $100. And then on the open container, we'll set the bond on that one at $100 as well. And did I say I was appointing a public defender? I think I did. Did I? No? Okay. I'm appointing a public defender. He qualifies.
I know. I tried to make the argument. Let's see how they can pull that up. So take this with you. That's the police report. You can have it since I printed it out. I want to make sure. Oh, that is it.
Good luck, sir.
This is just your arrest. They haven't been filed on yet, so they might not get filed on. Okay? And, Your Honor, for the next one, I just have a PC argument for the false name.
Good afternoon, sir. What's your name? He's hurting. He's Jones.
Dislocated.
Sir, what's your name?
Kurt Christopher Blunt, sir.
Kern Blunt?
Yes, sir.
You pronounce it Blunt or Blount?
Blunt.
Blunt, okay. Your chart, well, you got a failure to appear, sir. That's in Division 20. Says you failed to appear for a pretrial conference on May 31st. And you know what? The court set a bond at $1,000. They usually no bond people on that stuff. Did you have an attorney in that case?
He has the PD.
Yeah, the PD. Okay, you've already got the PD. And then you picked up some new charges, that being providing false ID to a law enforcement officer and resisting without violence. So it also looks like you qualify for the public defender. So I'll appoint the PD for you on the new stuff. Counselor, you said you had some argument on that one?
Yes, Your Honor. Defense would just argue that there's lack of probable cause for providing false ID to law enforcement. The alleged name that was given to law enforcement was Chris Blunt. His name is Kern Christopher Blunt. We would argue for that reason that it is not a false name. We understand it may not have been his full name, but it doesn't appear to be a false identification for him. Additionally, there's no information if he did provide a false birth date with that, because that would be more inclined to show that he was trying to give false information.
State?
I think, yes, Your Honor. In reviewing the affidavit, the name Kern Christopher Blount is the name that he was identified under. The name Christopher Blunt is a different name than Christopher Blount. It looks like the spelling is different, as well as, I don't know if there's a pronunciation, but Blunt and Blount are spelled very differently.
And I do, defense does note the spelling difference in the police report. However, defense would maintain the argument. He gave the name.
Actually, I think it's 6 of one, half dozen the other, the whole thing. Because there's the resisting charge. I can stay as bond at 500 on the resisting charge and ROR him on the other one.
Yep.
And, you know, that's something you can sort out when it comes charging time. And then, of course, he has the, what else do you have? He had the
failure.
The other one with a bond of $1,000. So he's got the PD in both cases. If you have any questions, sir, you can ask your attorney there.
I'm sorry.
I'm gonna let them know that you're in pain, okay? So take this with you. I just printed this out for my argument today.
Yeah, that's Jones.
You. Can I pass? He's having a hard time. You had 1,000 on the failure to appear and 500 on the new law, okay?
Okay, the other one is.
Nothing right now, but they could still file.
Step up there, sir. What's your name?
Lee Brandon.
All right, Mr. Brandon, you're charged with possession of ecstasy. You understand that charge?
I do, but if I could just say one thing.
Well, you hold off on saying anything until after you've had a chance to.
Yes, sir.
Let me do what I'm doing here. Now, you qualify for the public defender. You want me to appoint the public defender for you?
Please, yeah.
Okay, I'll do that. And indicate that my reading of the affidavit is that there is probable cause for the charge. And the normal bond amount on that is $1,000. Now, whatever you were gonna say to me, maybe you should run it by your lawyer before you say it to me.
I mean, I've thought about this. I can say it. I don't have to go with my lawyer. I mean.
What if your lawyer was gonna have a cardiac if you talked to me? Would you then talk to your lawyer?
Well, I wouldn't, this is exactly what happened. I mean.
Well, see, you're gonna talk to me about the facts of the case.
Yes, sir.
And she's way too young to have open heart surgery, and you're gonna cause her to have a cardiac
Right.
if you do that. So how about you just run it by her?
Well, okay, we were in a hard neighborhood and.
Your Honor, he can speak with his attorney in more detail.
Yeah. Good luck, Mr. Brandon. So bond stated $1,000.
I don't know, was $1,000, how, when can I get up? If I can't make phone calls.
Talk to your attorney. They can talk to you about different motions and things they can do to help you out, okay?
Who's the attorney?
You're gonna call that number. This.
Oh, okay. Say it in John.
You know, it'd be hard if you were over there and you felt like you could talk your way out of it, not to at least try. So try never to hold that against people, you know, the fact they're trying to talk their way out of it. That's human nature. What's your name, young lady?
Kristen Clark.
Ms. Clark, you're here because a capias was issued when you failed to appear on a cocaine charge for a status hearing in February of this year. And the court there in Division 14, very unhappy. And so they ordered you held no bond. So, did she have the PD in that case? Okay, you already had the public defender appointed. So you still got the public defender as your attorney. And unfortunately, you're gonna have to sit here for a while until the court in Division 14 says otherwise. Okay?
Okay.
Good luck to you. This one. They're all warrant. Warrant. Step up there, sir. You, Mr. Who are you anyway?
Hello, Cruz.
You're not Richard Christ? He did? His is all warrants, counsel.
Yes, Your Honor, his are all warrants, and I think a few of them have been filed on. We can waive his appearance if you appoint the public defender.
Okay, I'll appoint the PD on all the cases. Let's see, he's got a warrant for possession of methamphetamine. That has a bond of $1,000. Then he's got burglary of a conveyance twice, petty theft twice. The bonds are $1,000, 500, 500.
And Your Honor, some of the counts weren't filed on. I don't know if Your Honor is inclined to delete those bonds here.
Well, what wasn't filed on?
Let's see. So for 2022 CF 007620AO, if my notes are correct, count 8 was not filed on.
Which count?
Count 8, I believe.
She's correct. The grand theft was not filed.
Thank you for confirming.
Okay.
And then the other one is 2022 CF 004626. I believe that only 2 counts were filed on. They were 2 and 2 of the same counts, and I believe only the first 2 were filed on, if you want to confirm that, so I don't
The 2
misstate.
burglaries of a conveyance?
It's
It-
one burglary of a conveyance.
One burglary and one
and
petty theft.
Yes,
Okay.
thank you.
All right, so yeah, so let's delete the bond on the second burglary of a conveyance in 4626 and the, just do the first petty theft, delete that. And then as to 7620, we're only deleting count 8 and the bond on that. And then we got 5288, which is a grand theft with a bond of 2,500, also a warrant. So everything else stands, and there you go.
Second
Right, right. So you tell me when you're ready. I'm going to wait.
Thank you. Figured you understood, but I want you to.
You know, if I forget to say it today before I leave, it has been an absolute pleasure being back down here working with y'all. I kid you not. I really do enjoy coming down here.
That means you gotta come back.
Well, whenever they ask me. I'm not always welcome back after I've been somewhere. So you have to let me know I'm welcome back because, well, I could tell you stories about places I've been. You know, because when you're a senior judge, you can go anywhere in the state and sit as a judge. You're appointed to all of the trial courts throughout the state.
Actually did not know that.
Yeah, I didn't realize it until I became one, and I got the order from the Supreme Court saying I was appointed to the entire state. Right away, my mind went to, I want to go to Key West for a week. And And then I thought, no, I really don't, because I don't want to stay in hotels, motels, stuff like that. I'd rather be at home, but I do a little bit of traveling, get up to Seminole County. In fact, I'm up in Seminole County week after next, I think. It's a different world up there. Smaller, quieter. They have dockets that, unlike this, I do initial appearances up there periodically. And I've had dockets up there where I started at 9 o'clock and was done by 9:45. And that was considered a docket. It was more like just visiting, you know, but then, you know, they do what they do. So, not like it is down here. So you ready? Yeah. Okay. All right, yeah, tell me your name again, sir.
Philip Cruz.
All right, Mr. Cruz, you're being held on a grand theft charge. That's pursuant to a warrant where probable cause was found for that charge. That's in 2023 CF 8648. That court set the bond at $2,500, ordered you not to return to the Home Depot store as a condition. And then in 9045, it's a petty theft with 2 or more prior convictions, so it's charged as a felony. That is also pursuant to a warrant that orders you, sets your bond to $1,000, orders you not to return to the Home Depot store. And finally, in 9661, also a petty theft with 2 prior convictions. And in that one, your bond is set at $5,000. You're ordered not to return. Doesn't say where, it just says do not return. No contact directly or indirectly with victims. Do not possess any firearms or ammunition. And like I said, the bond is $5,000 on that. Now, it looks like you qualify for the public defender. Would you like for me to appoint them?
Yes, Your Honor.
I will appoint the public defender at this time to represent you in the cases. Thank you. Any questions you have, you can direct to your attorney. Good luck.
And then these are your contact us someone or your attorney's gonna get.
State all of it. In their current unattractive form.
No, you do have one though. But he didn't, I would have to check, but.
I did something this morning I haven't done in a long time.
Still there, yes.
Thank you. Some guy,
That's what happens.
I mean, came that close to clipping the front of the vehicle I'm driving. It's my daughter's Jeep. She would have had a cat.
Yeah, it's not set for today.
You know, he came around me and then he cut back in so quick. He couldn't have been more than 5 inches off the front bumper of that Jeep.
Your Honor, for the next one, I only have a PC argument as to the value of the alleged grand theft.
Is this Alex Ray Diaz?
No, no, sir.
Cranberry? Is that the
Cranberry, yeah.
No? Okay. Well, might want to look into that one and see about resetting them for tomorrow or something.
2301-9155.
He posted bond.
Bonded. Got it. Thank you, ma'am.
You're welcome.
All right, you must be Mr. Granberry, huh?
Yes, sir.
Well, you got robbery by sudden snatching as a charge. You got grand theft 3rd degree and battery. They're in Division 12. And you do qualify for the public defender. Would you like for me to appoint the PD for you, sir?
Yes, sir.
All right, I'll do that. So counsel.
Yes, Your Honor. Defense would just be arguing lack of probable cause as to the value for the grand theft and that it is a petty theft. Unless defense overlooked it, I do not see anything regarding the value of the alleged phone that was stolen. It says it was an iPhone 11. I'll be honest, I'm not fully up to date on the iPhones, but I believe we're at least 14 right now. And I think an iPhone alone without any value or additional information isn't enough for a grand theft.
Yeah, I agree. There's no value set in the affidavit, so petty theft would be the more appropriate charge there. So I agree with that.
Thank you.
As to the robbery, sudden snatching, there's certainly probable cause for that. Bond is $1,000. The grand theft, which finding no PC for, rather finding PC for petty theft is $100. and the battery is also $100. You are not to return to 7520 Chancellor Drive
Yes, sir.
as a condition of your release. You're to have no contact with the victim or victims. As a condition of your release, you're to have no contact with any witnesses as a condition of your release. And I think that'll do it. So if you have any questions, sir, you may want to direct them to your attorney there. Good luck.
Right now, you're arrested for felony? I'm gonna give you this report. I had it printed out.
Does Hodges have
So I'll let you have it.
the PD in all these cases on these
And then that's your,
that are coming up next?
Yes.
Okay.
of course, good luck with everything. Make sure you call your attorney when you bond out.
Your name, sir?
Anthony Hodges.
All right, Mr. Hodges. In 2023 MM2547, you're being held as a result of a capias being issued for failure to appear on May 11th for a pretrial conference. There were 3 counts. The court issued a capias, set your bond at $500 on each count, and so that total of $1,500. And you are represented by the public defender in that case. In 2023 MM1757, also a capias issued for failing to appear, and that was for a arraignment on March the 30th. 3 counts. Bonds on the capias are $250 on count 1, $1,000 on count 2, $250 on count 3. And then in 2023 CF 4347, you are charged, well, there's a capias there too, so, but I'm not sure was, well, and it shows 3 counts, possession of burglary tools, $1,500, tampering with coin-operated machine, $150, and criminal mischief, $1,500. You're also ordered not to return to the scene of the offense, not to possess any weapons or firearms. In 2023 MM2139, you got some failures to appear. 3 counts, it looks like. Bonds are set at $200 on each count for a total of $600. And in 2022 CF 13212, failure to appear for a pretrial conference on June 13th. That court in Division 10 ordered jail, no bond. And like I say, you've got the public defender representing you in each one of those cases. So good luck. I'm going into slow mode again to give you a chance to get through all those things.
Your Honor, did you go through the 2023 CF 4347? You may have. I didn't hear the case number. I just want to check.
Good afternoon, sir. What's your name?
Willie Hull. Good afternoon.
Willie James Hull, is that correct?
Yes, third.
All right. Well, Mr. Hull, you got some new charges. Unauthorized possession of a fictitious Florida DL, 2 counts of that, and 1 count of resisting without violence. You understand those charges?
You say resisting without violence, and what's the previous? The first?
Yeah, resisting without violence is the 3rd count.
What was the first 2 you said?
Unauthorized possession of fictitious Florida driver's licenses, 2 of them.
That's what they're claiming.
Okay.
All right. And I read the affidavit. I do find probable cause for the charges. Looks like you qualify for the public defender. Shall I appoint them to represent you?
Yes. No problem.
Okay, I'll do that. Your bonds Our 2,500 is to count 1, 150 is to count 2, 100 is to count 3. You're out on bond on ag battery causing harm. Looks like you're represented by the public defender in that case. Actually, you're out on ROR. Can you look, state, to see if the state's filed on that? It's 2023 CF 4089.
4089?
Yeah.
I have some other CF 4089. It's set for trial August 28th. It has been filed on.
Okay. All right, I'm going to revoke your status of ROR on that one. Direct that you be held no bond pending further order of the court in Division 20. Then in, well, this one's Division 22. You got a bond amount of $15,000 on that one. It's 4933.
It's a little slow. That case has been filed. It's set for trial on September 5th.
All right. I'll revoke that bond as well, your release status, and direct that you be held no bond pending further order of the court in Division 22. And in Division 11, you're ROR'd on 4935. I'll revoke that release status. Direct that you be held no bond pending further order of the court in Division 11. Now, looks like you've got the public defender already in all of those cases, and I'm appointing a PD for you on today's case as well. So good luck, sir.
Yes, yeah. It's misconstrued on the information that's given. It's only 2 charges. Was it's the misdemeanor and also the aggravated battery with a firearm. That was the only 2 charges that was upheld. All the other charges was R&R, but was not filed.
Right, okay.
Okay?
Thank you, sir. Huh?
It's with you.
All 3. Step up there, sir. What's your name?
Samuel Hunter.
All right, Mr. Hunter, you're being held on a charge of possession of MDMA. Having reviewed the affidavit, I do find probable cause for that. The bond on that charge is $1,000. Is it your intent to hire a private attorney, sir?
Bless you.
Sir, don't look at her. She can't answer it. Are you going to hire a private attorney in these cases?
Yes.
I don't have an affidavit of insolvency to see if you qualify. So the answer is yes or no?
Yes.
Okay, so to get on attorney. And then you have pursuant to a warrant, you're charged with 4 different counts of petty theft, at least 2 prior convictions. And each one of those carries a bond of $3,500 for a total of $14,000. And then there's a second warrant also charging petty theft with 2 prior convictions, bond is $3,500. No return to any Marshall's department store is a condition of that bond, and also on the earlier petty theft bond. And just to make sure I didn't do anything to it, the judge told me not to be modified by the IA judge. So, you understand all that?
Yes.
Okay. Well, we're gonna put you down as you're gonna get your own attorney. Good luck. Good afternoon, sir. What's your name?
Darren.
Darren
Jackson.
Jackson. All right, Mr. Jackson, you're charged with possession of a controlled substance without a prescription. That substance is alleged to be fentanyl, and I do find probable cause for the charge. Bond is $1,000. Did you not have a chance to fill out an affidavit of insolvency, or you gonna be talking to a private attorney?
No, sir, I didn't fill it out because I didn't have it. I just came to jail.
Okay. So you didn't have a chance to fill one out? Have you ever had the PD appointed for you before?
Yes.
So, okay, I'll go ahead and appoint the public defender to represent you, unless you tell me you don't want him.
Yes, I need it.
Okay. So, bond is $1,000. Good luck.
Take this with you. Good luck with everything, okay?
Love next? Ms.
Yes, I do.
She's bonded.
Okay, Love bonded. Wow, she qualified for PTR too. But I guess any way to get out of here quick. What's your name, sir?
Anthony.
Luton, is it?
Luton.
Okay. Well, Mr. Luton, you're charged with trafficking in MDMA, possession of a firearm with a serial number removed, and possession of drug paraphernalia. Do you understand those charges?
Yes, sir.
I don't see an affidavit of insolvency, sir. Are you intending to hire a private attorney?
No, sir.
You asking for the public defender?
No, sir.
No?
No.
You don't want a public defender?
No, I'm
Okay.
guilty.
Okay, so does that mean you're going to represent yourself?
Yes, sir.
Yes? Well, have you ever done that before? Ever go to the dentist?
I've been there one time.
Yeah. Why'd you go to a dentist?
It was a long time ago. I don't know why.
Did you have a problem with it or need your teeth cleaned or what? Is that what it was? Had some kind of dental issue?
Yeah,
Why'd you go to a dentist though? Why didn't you just do it yourself? Don't know how, do
Everybody
you?
needs a dentist approval. That's why.
Okay, well, it's no different here as far as a lawyer is concerned. If you have the option to have a lawyer, quite frankly, even a bad lawyer is better than no lawyer at all. But in this case, you're talking about some pretty good lawyers down there in the public defender's office. So maybe you ought to reconsider your decision to represent yourself.
Well, yeah, I'll get a public defender then.
Do you want one?
Yeah.
Okay, let's do that. I'll appoint the PD. Now, your bonds on these things, that trafficking charge, they've got that written down as no bond, but, counsel?
It's
Let me hear your wisdom on that.
Your Honor, it's not punishable by life or a capital offense, so it is entitled to a bond.
Okay. State, care to be heard on the amount of the bond?
No, Your Honor.
Okay. Set the bond on that one at $25,000. $150 on the possession of a firearm with a serial number removed, and $100 on the paraphernalia charge. And I've appointed the public defender for you, sir, so good luck.
All right.
Now, what's your name, sir?
Victor Jesus Martinez Otero Jr., sir.
Okay, Mr. Otero, you're being held on a capias that was issued when you failed to appear for an arraignment on June 14th of this year. The court in Division 10 ordered that your bond be forfeited and that your release status be revoked and that you be held no bond pending further order of that court. Now, did he have a PD in this case or an attorney at all?
My notes indicate he didn't have an attorney at all.
That's probably, that contributes itself to failing to appear. Can you afford an attorney?
No, Your Honor.
All right, I'll appoint the public defender for you, okay? All right, and bond is, unfortunately, no bond. I have a Harrington Maxwell. Bonded, okay. Next up, your name, sir.
Isaiah McFadden.
Mr. McFadden, you are being held on a capias that was issued for failing to appear for a pretrial conference on November 30th of last year. That was on a driving while license revoked as a habitual offender. That being a felony, the court in Division 20 has ordered that you be held no bond pending further order of that court. Did he have an attorney?
Mr. McFadden, yes, he had the PD.
PD, public defender already represents you, sir. So, good luck.
They did have an offer, which was a misdemeanor. I'm just looking at the notes. It looked like a misdemeanor, no valid, adjudicate guilty, court costs, cost of investigation, $75.94.
If he's interested.
But it's still a felony right now. It's just a matter of if he accepted it, they were going to reduce it to an NVDL?
Yes, it
Okay.
looks like most of his suspensions are financial between 2018, 2019, again in 2020, 2021.
I just want to make sure I have it right. If he does wish to resolve his case today, the state is willing to amend to a no valid, an adjudication of guilt, so it would be a formal conviction and credit for time served. And what was the cost of investigation? I apologize.
$75.94.
So
Huh? Well, but she may be reducing it to a misdemeanor. Oh, yeah, that's going to be an issue. We can't really resolve it as long as it's under a felony case number. It's got to have a reassigned misdemeanor case number before it can be
I thought
let
this-
out at IAs.
Oh, at
No, it can't be
IAs.
split out
I was going to say this because couldn't the state orally amend, but I guess IAs is a different ballgame.
Well, yeah, the rules are different at this point. Can't really resolve it. I was sitting here thinking that because it's still under a felony case number. And until it's assigned a new misdemeanor case number,
I don't know if it needs, Your Honor, and I may not be correct on this, but I understand initial appearance is a different thing. I don't know if it actually needs a new case number when it resolves as a felony, but I could be wrong. It's been,
No,
a-
but it will get
Lesser
one.
included if we include the statute number.
yeah, if it's a plea to a lesser included.
It's a
I
lesser,
don't think we can do that at IA.
Understood.
okay.
I think that's beyond the pale of the court's jurisdiction at this point. So, well, you just need to get him in front of that court in a big-time hurry, and then you can resolve it down there. All right? Good luck, sir. And what's your name, sir?
Kenneth McGill.
Mr. McGill. You're being held on a capias issued when you failed to appear for a pretrial on May 9th and a cocaine charge. That's in Division 10. Division 10 has ordered you held no bond pending your appearance in front of that court. And does he have the PD? And the public defender has already been appointed to represent you, sir.
Yes, sir.
Good luck.
This with you? Thank you.
Your Honor, next on the docket was Molden, Garris.
Yeah,
He's not here due to medical reasons.
okay, medical, so must reset Mr. Molden for tomorrow, unless you want to waive his appearance, counsel.
Your Honor, we can reset it. He has a bond. I don't think it's
All right.
gonna hold him up.
Okay. So reset for tomorrow. What's your name?
Kelsey Byers.
Mr. Byers, you're being held on a capias that was issued when you failed to appear for a pretrial conference on April 18th of this year on a fentanyl charge. And your release status was revoked by that court, and the court ordered that you be held no bond pending further order of the court in Division 15. Did she have the PD?
Ms. Byers, yes.
Okay.
Believe she-
And the public defender already represents you.
Oh, yeah.
Sorry. Oh, okay.
Good luck.
Thank you.
You're welcome. What's your name, sir?
Mr. Potts.
Mr. Potts, you're being held on a failure to appear. Let's see, failed to appear for arraignment on September 22nd of last year on a grand theft charge. The court in Division 16 has ordered you held no bond pending further order of that court. Did he also have the PD?
He has no one.
Got no lawyer. How'd you like to have one?
Oh, yeah.
Shall I appoint a PD for you?
Yeah, that's fine. Yes, sir.
Well, in case you didn't, I'll go ahead and appoint him.
Thank you,
Okay?
Your Honor.
Good luck, sir.
So I don't have an next.
You should have another court date. I don't have it in front of me right now, but you'll be able to talk to your attorney assigned to the case and they'll let you know.
Your Honor, Richardson, Scotty, he refused.
Scotty Richardson, okay. Does he have the PD?
I believe he does. I just would want to double check, but I do believe he does. And we can waive his appearance.
Well, let's see. Failed to appear for a pretrial conference May 18th. Hey, the court issued a capias and set his bond at $500.
He has a PD.
He has a PD. So his bond is $500. His appearance is waived today by counsel.
What happened to the first guy?
Let's see, what's your name, sir?
Alan Charles Richmond Jr.
Oh, Richmond.
Yes.
Right? Okay. Mr. Richmond, what do we got here? Let's see. Well, the new charges are possession of cocaine and possession of a misdemeanor amount of cannabis. I do find probable cause for those charges. It looks like you qualify for the public defender, sir. Shall I appoint them to represent you?
Yes, sir.
All right, I'll do that. Your bonds will be set. I'll stay the bond at $1,000 on count one. Bond on count two will be lowered to $100. And no action on the case he's out on bond on.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. Welcome, sir.
Okay.
So does this mean I can call my girlfriend?
Good afternoon, sir. What's your name?
Joseph St. Fleur.
Mr. St. Fleur, you're being held on a capias issued for failed to appear for a status hearing on April 4th of this year. And you do have the public defender already representing you. The court in Division 15 has ordered you held no bond, and there's those words, bond not to be modified at initial appearance. So, you understand all that?
Yes, I want to ask you, please, if I can get a bond, Judge, please.
What?
I ask you, please, if I can get a bond, please.
You're asking for a bond?
Yes, please.
Sir, the court in Division 15 specifically put on the capias that it was not to be modified at this point. And that being the case, I'm not authorized to modify the bond. So you'll have to deal with a court in Division 15 for that, and that's what your attorney will do. Okay, good luck. It used to make me angry when I was down here working on a regular basis when they would tell me I couldn't modify things. It was, I don't know why, it made me angry. I don't know. Okay, so, now Mr. Sanchez has a bond, so counsel, if I appoint your office, you want to, I'm gonna do that anyway.
We can waive his appearance, Your Honor.
Okay. Well, he's charged with petty theft with 2 or more prior convictions, so his bond is $1,000, do find probable cause, and I've appointed the public defender to represent him, so waived appearance.
Judge, he's currently out on PTR.
Huh?
He's out on PTR also.
Oh, he is? In addition to the,
Mark Sanchez, I gave you the.
We'll talk about that in a second.
oh, I see, okay. Let's see, took into consideration, all right, so let me just sign this thing. No capias being issued, took into consideration conditions of release on new case.
And Your Honor, I would just state that it is the exact same offense that he's on PTR for.
Yeah.
Which is another petty theft, 2 more priors.
Okay, there we go.
And Your Honor, I apologize. Was there any action on the out on bond?
No.
Okay, thank you.
Demondre Lee Scott?
Yes.
Is that you, sir? Okay,
And I do have a probable cause argument on this one.
all right. Let's see, the charges are possession of cannabis with intent to sell or deliver with a weapon, possession of tetrahydrocannabinoids, ooh, big name. Public order crimes, keeping public nuisance structure for drug, something or another, and possession of MDMA. He qualifies for the public defender, so I'll appoint the public defender to represent him. Counsel, did you know he also qualifies for PTR?
Yes, Your Honor, I did explain that to him. I understand that that means the probable cause arguments might not matter, but I'd like to lay the record just in case.
Go right ahead.
Thank you, Your Honor. Defense would just be objecting to lack of probable cause for 3 of the counts. We'll start with count 4, the more serious one. Count 4, it's not listed this way, but it is a trafficking in MDMA greater than 10 grams. Unless defense overlooked it, I believe there was only 4 grams of MDMA located, meaning it does not meet the qualifications for trafficking. And for that reason, we would object to the trafficking portion of that and say it's a simple possession.
Okay, let me deal with them one at a time.
Yes, Your Honor.
I'll agree and find no PC for trafficking, a PC for simple possession.
Yes, Your Honor.
That's just count 4.
Perfect. And then for count 2, possession of tetrahydrocannabinols, that one, I don't see that that was actually tested. Again, defense may have overlooked it, but if it wasn't tested, defense would be arguing lack of probable cause, as that usually is something that needs to be tested to confirm what it is.
Yep, doesn't appear it was. So, okay. Granted.
And then the last one is count 3, the public order crimes, keeping a public nuisance structure for drug paraphernalia. Again, this is one that defense is not super familiar with, but I believe it has to do with the intent to sell drug paraphernalia or some relation to that, and I don't see any information regarding that. And for that reason, defense would just argue lack of probable
Now that
cause.
one I'm gonna find PC on because it's about keeping a structure or business for the purpose of allowing people to use drugs in there. So that one I'll find PC for, but he qualifies for PTR, so I'll authorize his release PTR. Now, you're gonna have a lot of rules, including drug testing going on when you're on PTR. And they're gonna give you all those rules and, you know, you comply with them, okay? You don't comply with them, you come back here and we start talking about, one of these bonds is set at $50,000, you know? So it's a big one. And okay, I'll authorize PTR, your, to consume no alcohol or drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Any weapons that you own that are still in your possession, you're to turn into the sheriff's department within 12 hours of your release from custody. Okay?
Judge, did you want testing?
Pardon me?
Did you want testing for the
Tested?
PUAs?
Yes,
Okay.
I do.
Can we request that the first testing be 30 days out? That's to allow them to clear out their system.
Sure.
Thank you, Your Honor. They're gonna do drug testing, okay? Do this whole thing again.
Well, we'll revoke PTR, but I'm not issuing a capias. So, it's just not gonna be on PTR. Makes sense? You hope? Oh, well, as long as. No, he's just, there's no bond, there's no nothing. Just take him off PTR.
He said, I'm trying to listen to what they say.
Good afternoon, sir. What's your name?
Sean Spivey.
All right, Mr. Spivey, you are charged with, and this is pursuant to a warrant, criminal mischief, and discharging a firearm in public. Do you understand those charges?
Yes, Your Honor.
All right. Well, the warrant has you being held no bond, and typed in at the bottom of it is facts presented in PC affidavit indicate the defendant may be a danger to society and others. No firearms, no weapons, and no contact with the victim. Interesting. So, I read that as if the judge who signed the warrant is trying to tell me that I should consider holding him on no bond on these charges.
Your Honor.
Let's assume that's what the judge is asking, and you can respond.
Your Honor, I'd have to pull back up the affidavit and double check, but in my review, my notes indicate that it's not a punishable by life offense, nor is it a capital offense. Therefore, he is entitled to a bond on both counts. You can add conditions, no firearms, things like that, or a higher bond to account for it. However, he is entitled to a bond, as this is a new law offense.
Yep.
And Your Honor, I will say that the defendant is already out on bond on a previous case.
He is?
We have another case, 2023 CF 9363 with the exact same charges. (2023 CF 9363).
The other case?
It's the same charges.
He's being held on 2023 CF 009363AO. He's currently being held on those charges.
No bond?
No, he has a bond. This was actually, I believe this was called this week, or the other week, and this case came up recently, Your Honor, and he is being held on the case that state is referencing. He does have a bond on those.
He hasn't bonded.
He hasn't bonded because the bond is quite high,
Okay.
would be my assumption.
Any idea about dates? The warrant
Yeah.
indicates that these offenses occurred 11/9 to 11/10/2022.
The other case is from July 12th, 2023.
Okay, so
It was after,
which case are you talking about? That's July 12th, the new one?
the 2000 CF 239363 occurred on July 12th from the affidavit for the warrant.
So well after the one that's mentioned in this warrant. This warrant being 11/9/2022 and 11/10/2022. Am I hearing that correctly?
It just says that on July 12th, I'm not able to get a lot of information. That's when he was contacted. I'm trying to pull up more documents. Give me 1 second.
I do see some 2023.
July 9th, 2023. It looks like there was a call for service, July 9th.
And does it show that he was arrested on that day?
Not on July 9th. Then there was a July 12th incident.
These all happened after the case we're here for today.
Mm-hmm.
So, at least what I'm seeing. But he was just served on this warrant. It's new to him, and it is a new law offense.
Okay. As the day gets later, I get dumber. So let me make sure I understand what y'all are telling me. You're telling me that there are outstanding criminal cases right now that he's out on some type of release on?
He's in custody on them.
Yes.
Okay.
He's being held on them currently.
But he has bonds on them,
He does have.
the ones that have come after this warrant that I'm looking at.
The warrant, the date of the incident on those were after the date of the incident on our current case, but he was just served on those warrants on the 12th.
Because you know what I'm thinking? I'm thinking about revoking the bonds that he's currently out on
Your Honor,
for the incidents that occurred after this incident that's in the affidavit that I'm looking at.
Your Honor, the ones he's out on bond on occurred in July of this year.
Uh-huh.
So you can't revoke those bonds for an incident that happened prior. The case we're here for today, hold on. The case we're here for today happened prior to the incidents that he is currently being held in custody on. And therefore, they did not happen after the fact. And defense would argue that therefore they are not a basis to revoke his release as they were prior to those.
Okay.
If that makes sense. Sorry, there's
Yeah,
a lot of
it does.
dates.
It makes all the sense in the world. You would agree or disagree, State?
I'm just verifying the dates again, just. So this, it looks like it's from November 2022. This was from November 2022, the case that we're here for today. And it looks like some were in January 2023. I'm gonna go back to the other one.
And again, he was just served on this warrant, so it is a new law offense.
Well, I got to deal with this one. So, he's currently no bond on both of them. I do agree that the nature of the charges is such that he's entitled to a bond. So his bond as to count one, the criminal mischief charge, I'll set the bond on that one at $25,000. His bond on discharging a firearm in public, I'll set an additional bond of $15,000. You're ordered to have no weapons on or about your person if you're released. As a condition of your release, no contact with any victim or victims or witnesses as a condition of your release. And we'll move it on. So,
Thank you, Your Honor.
let's see. Step up there, sir. What's your name?
Daniel Sullivan.
What is it?
Daniel Sullivan.
Okay, I have a Yancey Williams Styles. Okay, mental health.
And we can waive his appearance.
All right, well, he's got a new charge, possession MDMA, which I find probable cause for. That bond is $1,000. He's also being held on a failure to appear, capias.
Yeah.
For camping, really? Failed to appear for a pretrial with a bond of $1,000. So his appearance is waived for today. Okay, you said your name was Sullivan, right?
Sullivan.
All right.
Daniel C. Sullivan.
Let's see, Daniel C. Sullivan. Mr. Sullivan, you're being held on a possession of MDMA charge. Do you understand that charge?
I shouldn't. I understand it. I shouldn't have had anything on me. I'm not sure what they found.
All right. You do qualify for the PD, so I'll appoint the PD for you, and the bond on that's going to be $1,000. I'll take no action on the case you're out on bond on.
You have $1,000 bond on the new case. He's going to take no action on the out on bond. So, yeah, you have a $1,000 on your current case, the case you just got arrested for. You have another case that you're out on bond. Don't forget about this case, okay?
You know, I'm gonna need to straighten out that PTR case. I know that's causing you all a lot of heartburn, so before I go, we'll straighten it out, okay?
He didn't do anything. You just have to bond. You have to bond out.
I never have to be in such a hurry that I can leave all that
They'll help you contact the bondsman, and they'll,
in my wake.
so corrections officer should be able to tell you, and so let them know you have questions about bonding out.
Yes, sir, step up. What's your name?
Good morning, Your Honor. My name is Nicholas Bellocchio.
Mr. How do you pronounce your last name?
Bellocchio.
Oh, how about, yeah, bond, okay. That's difficult. Well, Mr. Velocchio, you are being held on a warrant, capias, that was issued for failure to appear at a pretrial on May the 3rd. And that's in Division 14. The court in Division 14 has ordered you held no bond. Does he have the PD?
Yes.
Okay, and you've already got the public defender representing you, sir. All right? Pardon me? Well, you probably want to say it to your lawyer, not to me.
Yes, ma'am. Your Honor, I've been in custody since March 24th.
You what?
I've been locked up in jail since March 24th
Well,
for the FTA. I don't know how.
here?
And I've been from Bay County to Lake County and then here.
Okay. Well, you've got an attorney. What your attorney's gonna do is go to the court in Division 14 now.
Yes, ma'am. Yes,
Show
sir.
proof to that judge that you've been actually incarcerated,
Yes, sir.
and I'm sure the judge will change your release status at that point.
All right.
Good luck.
To present that.
Thank you.
Good luck with everything.
Good afternoon, ma'am. What's your name?
My name is Natara Zara Williams.
What was it again?
Natara Zara Williams.
How about Vanell Vernette?
You have one case to address first, then talk to me, okay?
Okay, medical, so
We're addressing one other case first, then tell me.
she doesn't have the PD. PD on Vernette, she's medical, or he is medical. Yeah.
Your Honor, we can waive his appearance for that one if you appoint the public defender.
Yeah, I'll go ahead and appoint your office. Bond on count 1 is $2,500. Counts 2 and 3 is $100 each, and I do find probable cause. Okay, Ms. Williams.
Yes, sir.
You are charged with
Listen to the
trafficking in methamphetamines, that's more than 28 grams. Trafficking in MDMA, which more than 14 grams. Petty theft with 2 or more prior convictions, and possession of drug paraphernalia. Do you understand those charges?
He just wants to know if you understand the allegations. You don't have to agree with them.
Ma'am,
If you understand.
I'm talking to you.
Yes, I was trying to make sure I understood you, sir.
Okay, but do you understand what you're charged with?
Yes.
Okay. Well, now you qualify for the public defender as well. Would you like for me to appoint the PD for you?
Yes.
All right, I'll appoint the PD for you. I did review this affidavit twice, as a matter of fact, and there is probable cause for each one of those charges. Now, the bonds, unfortunately, are rather large when it comes to these trafficking cases. So your bond is to count 1, that's the trafficking in methamphetamines, is $100,000. The bond on count 2, I'll set at $150. Count 3 is $150, and count 4 is $100.
And Your Honor, we understand that the court has already significantly reduced the bond in count 2, and we are gracious and thankful for that. However, we are asking if there can be a further bond reduction to count 1. She currently has a 2-month-old at home that she is breastfeeding. She additionally, in addition to taking care of her 2-month-old, she's also taking care of her elder mother. She was also working from home and gainfully employed to help support and take care of her family. I don't know if this incarceration will affect that.
Yeah, do you also have a copy of this?
Yes.
Mine is blurred out right where I need to see it down there. Let's see if yours is better than mine. Barely. She's got a failure to appear on her record, so no, I'm not going to reduce her bond. Thank you.
Your Honor, can you tell me when is a failure to appear? I've never not did what I was supposed to do on a certain date or time. 5/26, I've never.
I don't have the date for that, ma'am. Good luck.
It's still the same amount. Okay, I'm asking.
She is? I can't hear anybody.
Hello?
Oh, there we go. All right. Are you the Creole interpreter?
Haitian Creole interpreter, Your Honor.
Okay. Yeah, it's always a good idea to let me know you're there because I can't see you.
They just transferred me up, sir.
And you're breaking up too. So I'm gonna
Yes, and I'm hearing an echo on the line also.
Yeah, I'm gonna turn this thing down a little bit, see if we can stop you from breaking up. Okay, Madam Interpreter, if you would identify yourself, please.
Name is Margaret, ID number 208940. I'll be your Haitian Creole interpreter.
All right. Have you been previously sworn today?
No, Your Honor.
All right, if you would raise your right hand, the clerk will swear you in.
Do you
Yes.
swear or affirm to translate from Haitian Creole to English and English to Haitian Creole with the testimonies given today?
I swear.
All right, thank you.
You're
Okay,
welcome.
now, Madam Interpreter, we've got the defendant and the witness, both I understand require your assistance here this morning. So I'll be talking to the defendant first, and then when I switch over to the witness, it should be fairly obvious.
Yes, Your Honor.
All right, sir. Good morning. Tell me your name.
Bonjour, monsieur. Comment relais?
Maxime Fleurantis.
Maxime Florenti.
All right. You are before the court today, sir, charged with battery. Do you understand what you're charged with?
Ou devant tribunal la jodien, et yo accusé ou de coups et blessures. Bon, ça charge?
I apologize. I don't mean to interrupt him. If we can just let him know that the judge is just asking if he understands the allegations against him, not asking about the facts or what happened.
Donc, juge là seulement mando sous comprendre accusation yo fait contre yo pas mando pour parler de qui ça qui passé là.
Non, m'ba comprendre non.
I don't understand.
Do you know what battery means?
Est-ce qu'on connaît ça veut dire coups et blessures?
Non, m'ba connais non.
I don't know.
It means touching somebody without their permission.
Ça veut dire moyen au monde sans pas avoir permission. Okay.
All right. So you're charged with the criminal offense of battery.
Donc yo accusé de offense criminelle que il frappé moun.
Now that is pursuant to a warrant that was signed, at which time the court found probable cause for the charge.
Après yon warrant, après yon mandat, tribunal l'enjoint une cause probable pour accusation.
Now, do you understand that, sir?
Vous comprenez, monsieur?
M'ba connais qui est-ce m'ba connais.
I don't know who I'm talking to. I don't know.
Strange response. Okay, well, I'm going to talk to the witness now, Madam Interpreter. Ma'am, would you tell me your name?
Donc, combien de témoins? Est-ce qu'on dit, madame, comment relais, s'il vous plaît?
Fabiola Charles.
Fabiola Charles.
All right, now, you are related to this gentleman? Is that correct?
Est-ce que, qui relation il y a avec monsieur ça ou c'est relation avec lui? Yes, it's my husband.
Okay. You are the named victim in this case. Do you understand that?
C'est vous-même qui c'est victime qui désignait dans le dossier. Est-ce que vous comprenez?
C'est moi-même qui est victime là?
I'm the one who is the victim?
Yes.
Oui.
Okay.
I'm drawing a blank on my next question. I've only asked that question 48 million times, and now I can't remember where to go with it next. Uh-oh, senility.
Do you want me to ask, Your Honor?
No, I gotta sit here and straighten this up. So you're here today to talk to me about not necessarily what happened, but what you would like to have me do.
Nous la jotiens pour nous parler, pas nécessairement de ça qui est passé, non, mais ça t'a aimé que nous faisons.
Bon, pour ça, moi, te fait report là, m'kwe, sous 3 jours, monsieur te ban moi tout bagay, même pas te faire report pour te arrêter, te fait report pour te ban moi document.
Oh, hold on. I'm so sorry, Your Honor. I can't hear. I can't hear everything she's saying.
Yeah, she's behind a glass wall and the microphone is set up so that if you're taller than 4 foot 2 inches, your head is way above it. I wonder if they had a really short witness the day they installed that microphone. Ma'am, you're gonna need to talk louder and get closer to that microphone so that the interpreter can hear you.
S'il vous plaît, madame, est-ce qu'on peut parler plus fort? Mettez comme plus près micro pour interprète la attendre, s'il vous plaît.
Okay.
Okay, can you hear her now, Madam Interpreter?
I heard okay, but I want her, when she starts talking, then I will know.
Okay. All right, so you just told me something. Would you tell me that again, please?
So, dit à l'heure, s'il vous plaît, est-ce qu'on peut répéter, s'il vous plaît?
Moi, dit pour ça, moi, te fait report là, li te ban moi yo, m'pa besoin de faire rien encore. I did
the report. I filed the report. He gave them to me. I don't need that. I don't need you to do anything else.
So let's try it a different way. Do you want him to get out of jail?
T'en parlons l'autre façon. Est-ce qu'on voulait que yo retire la prison?
Oui.
Yes.
And do you want him to come back and live where you live?
Est-ce qu'on voulait retourner venir habiter même côté avec vous?
Non, yo ka la gueule, but il pas besoin habiter même côté avec.
No, they can release him, but he doesn't need to come live with me.
So you want him, if he gets out of jail, to stay away from you?
Donc, s'il sortit de prison, vous voulez pour le rester loin?
Oui.
Yes.
Okay. Now, does he own any weapons of any kind?
Est-ce que il possède aucune arme, aucune qualité arme?
No.
No.
And do you think that he will listen to what I tell him to do? Do you think he'll follow my orders?
Est-ce que vous pensez que la pouté, ça m'a demandé pour le faire? Est-ce que la suivre l'ordre que m'balé?
Bon, bah, connais.
Well, I don't know.
Well, you know him better than I do, so that's why I ask you that question.
Mais on connaît le plus mieux que moi-même. C'est pour ça que je me demande question ça.
Bon, moi-même, à plusieurs fois, les nous qu'on bagay, me kon toujours mandé pour le déplacer pour quitter Kaila, il pas accepter, but pour nous-mêmes, bah, connaît c'est la fait.
Several times when there is something between us, I asked him to leave the house. He doesn't leave. So, but I don't know if you ask if he will do it.
Okay. Now, is there anything else you wish to talk to me about today, ma'am?
Est-ce que vous avez l'autre bagage ou vous voulez parler avec moi de je dis, madame?
Bon, c'est ça que je voulais dire, parce que les gens qui sont malades, nous juste voulons payer la gueule et puis pour le faire autre.
Well, the only thing I want to say, he is a sick person. I just want it to be released and then that he goes his own way.
So, it sounds like you believe he has mental health issues.
Il me semble qu'on pensait que il a un problème santé mentale.
Yo te dit ça dans l'hôpital hier parce que c'est mercredi elle descend l'hôpital même pas connaît. Yo te dit ça.
They told me at the hospital where he was at, because it's Wednesday that he went to the hospital. They said that, but I don't know.
Okay. All right, thank you, ma'am.
Merci, madame.
Now, I'll just say for the record so it's clear down the road, my impression is there's some mental health issues with this gentleman. And
would you want the interpreter to interpret that part?
yeah,
No,
sure,
no?
go ahead.
OK. Donc, pour dossier, m'abdil, pour ça clair, l'impression que j'ai, c'est que monsieur ça a quelques problèmes santé mentale.
So I'm going to set his bond at $500.
Donc, m'a établi caution pour lui, bon nan, m'a mette la $500.
He does qualify for pretrial release in the
I
alternative.
saw that. And I'm going to give him the alternative of also pretrial release in lieu of the $500 bond.
We leave the 500?
Madam
I'm sorry, Your Honor, would you mind repeating for the interpreter? You're going to give the alternative of pretrial and?
Yeah, I'm going to let him make the decision as to whether he goes out on pretrial release or posts a $500 bond.
So, m'a quitté celui qui fait décision, s'il voulait aller pour yo la lan pour pré-procès, ou bien s'il a payé bon $500.
Now, you, sir, are going to be ordered to have no contact with your wife.
Donc, monsieur, y a bay l'ordre pour pas avoir aucun contact avec madame.
You are to maintain a separate residence from your wife.
Ou fait pour habiter non l'autre côté qui pas même cas avec madame.
You are to consume no alcohol and no drugs not prescribed for you by your own doctor.
Ou pas fait pour consommer aucun alcool, ou pas fait pour consommer drogue, ou pas fait pour prendre aucun médicament que le docteur pas prescrit.
You are to have no weapons on or about your person.
Ou pas fait pour gagner aucun arme, ni sur vous, ni autour de vous, des personnes.
Now, I want you to listen very carefully to the next words I'm going to say.
Kounya écoutez avec un pile attention pour bien entendre prochain bagay que m'bral di ou la yo.
I will allow you to go back to the marital home one time in the company of a law enforcement officer.
Ma permettre pour aller dans kay madame nan une seule fois en pour gon officier des forces de l'ordre qui accompagne ou les ça.
And that is to recover your personal effects only.
Et ça c'est pour aller chercher bagay personnel pa ou simplement.
If you go back there and you don't have a police officer with you, you will be arrested and you will come back to jail.
Si ou à l'autre bord, sans que pas aucun officier police qui accompagne ou, il a arrêté ou encore, il a retourné en prison.
Now, sir, do you understand what I've told you?
Monsieur, ou bien comprendre ça m'dou là?
Oui.
Yes.
And you understand that your attorney is the Office of the Public Defender?
Et ou bien comprendre que avocat ou c'est bureau défenseur public?
Oui.
Yes.
Any questions you have, you should direct them to your attorney.
Quelle que soit question gagnée, c'est avocat là pour demander yo.
Okay.
Thank you, sir. This
Your
hearing's
Honor.
concluded.
Your Honor,
Yes,
pretrial
Monsieur
release
Mufti.
has asked if we can confirm which option he would like, pretrial release or the 500.
No, I've spent enough time on this
Okay.
case. I'm not going to do anything else. So, good luck, sir.
Bonne chance, monsieur.
Thank you, Madam Interpreter.
Phone number, give us a call.
You're welcome, Your Honor. If nothing else for me today, thank you for using our services. Have a great day.
You do the same.
Thank you, sir.
Well, I always have the impression when we do one of the interpreter cases, particularly Creole, that the person leaves that place and they don't have a clue what just happened. So I decided I'd take my time and walk through it very slowly and see if that would work. And I firmly believe that I'm in exactly the same place I was in before. You don't know what's going on. Yes, ma'am. Oh, that's our Chinese interpreter? Okay. Next case is Brian Feng Zin.
下一个案子是 Brian Bing Zhang。
Good morning, Mr. Interpreter.
Good morning, Your Honor. I'm ready. Thank you.
Okay. Have you been sworn today?
Not yet. Not yet.
Okay. If you would raise your right hand, the clerk will swear you in.
Yes, Your Honor.
Do you swear or affirm to translate from Mandarin Chinese to English and from English to Mandarin Chinese, the testimonies given today?
Yes.
All right, thank you.
Yes.
I do,
yes,
Your
sir.
Honor.
Yes, Your Honor.
Mr. Interpreter, if you would go ahead and identify yourself for the record.
Sure. This is the Mandarin interpreter. My name is Alex. My ID number is 217005.
All right, thank you, sir. Now, good morning, sir. Tell me your name.
My name is Brian Feng Zhen.
Do you not need the interpreter today? It's
I
the
do
victim
not
that.
need an interpreter.
Okay, I
today.
got it.
My
Got it.
ex-wife may need an interpreter.
So if you just hang in there with us for a few minutes, Mr. Interpreter, after I talk to him, I'm going to be talking to the witness, and the witness will require your services.
Sure. Thank you, Your Honor.
You're welcome, sir. Well, Mr. Zinn, you're charged with battery. It's alleged to be a domestic battery. Do you understand that?
I understand that, but I did nothing wrong.
Okay, I understand that. But all we're talking about now is what you're charged with. Now, I reviewed the affidavit here. My job at this point is to determine if probable cause exists for the charge that's been, that you're being held on. Having read that affidavit, I do find probable cause in it. So there are grounds for you to be for you to have been arrested and for you to be here now. Now, where we're going to go from that is we're going to talk about your conditions of release. How you're going to get out of this place, okay? All right? I don't mean to treat you like you're a first grader, but I just want to make sure you understand everything that's happening here, okay? All right. Now, the way I'm going to do that, having found probable cause, is I see that you qualify for the services of the public defender. That's an attorney, right there. And appoint them if you want me to appoint them as your attorney.
Yes, could I beg your honor that I have two attorneys? I represent myself and my attorney represents.
Well, you know, everybody represents themselves.
Can I have two attorneys?
Two attorneys? No, you can only have one.
Okay.
If the public defender decides to give you multiple attorneys, then that's between you and them. But at this point in time, I'm only giving you one. Okay?
Thank you, Your Honor.
And then later you can talk to your attorney about why you might need multiple attorneys. All right. So, having done that, I'm now going to speak to your wife. All right. So, ma'am, if you would tell me your name, please.
林兆，Lingzhao。
Ling Zhao.
All right.
L-I, sorry.
Yeah, I've got a correct spelling of it in my file. I don't need you to spell it. You are Mr. Zinn's wife, is that correct?
ex-wife，
You know, we have an interpreter. Let the interpreter do his
前
job
妻
before you answer.
离婚了，我们已经离婚1年多了。
Your Honor, with your permission, I'm going to relay your information to her. Sounds like she kind of over-talked to you.
Yeah, she's doing that. So yeah, if you could just remind her that she needs to let you do your job before she responds.
Sure, thank you, Your Honor. 小姐是这样的，法官刚刚正在讲话的时候呢，你在讲话，这样是不好的。他的讲话是，他讲完之后，我再翻译，我翻译完之后你再讲，然后我再帮你翻译。我们有一个顺序，一步步的来，好不好？
好的，谢谢，懂了。
Okay, yes, Your Honor, we are ready.
All right. Now, you are Mr. Zinn's wife, is that correct?
你是 Zen 先生的太太吗？
不是，是前妻。
No, I'm the ex-wife.
Okay, you're his ex-wife. You are the victim in this case. Do you understand that?
小姐，在这个案子当中，你是这案子的受害人，你是否明白呢
是的。
？Yes.
All right. What would you like to have me do today as far as his conditions of release are concerned?
小姐，那么今天关于这位先生被有条件释放的这件事情上边，你希望我来做什么？
我希望他搬出我希望他搬出我们现在共同所有的这套房子里面，就是get injunction， 就是他是前2天搬回来的，我想让他搬出去，不要跟他生活在一起。
等一下。So I'd like to have this person move out from this property, which is we own together. And then she mentioned, this is interpreter, she mentioned the word injunction in English. And he moved into this property a few days ago. Yes, Your Honor.
Okay. So you do not want him to come back to the house where you live, is that correct?
也就是说，你不希望他回到你现在住的地方，对不对？
是的，因为他有那个精神病。
Correct, because he has a mental issue.
Okay. And you want him to stay away from you, is that correct?
你希望他不要靠近你，对不对？
对的，我和小孩都感觉到不安全，因为他在的时候，他会对我们进行各种精神暴力和语言暴力，控制我们。
请稍微等一下。Correct, because if he present, the child and me will not feel safe, and he will use language and mental to abuse us.
Okay. Now, you said something about an injunction. Did you say you wanted to get an injunction against him, or you have one?
小姐，你刚才提到了一个单词叫 injunction， 你是已经有这个 injunction， 还是你希望取得一个这个东西呢？
我没有，我希望取得一个这个。
I do not have one. I would like to get one.
You know that you have to go downtown to the main courthouse to apply for that injunction.
小姐，要取得这个 injunction 呢，你需要去到下城那个主法庭，就是市中心的主法庭去取得这个 injunction。
好的，好的，谢谢。
Okay.
All right.
Thank you.
Now, is there anything else you wanted to talk to me about today, ma'am?
昨
小姐，
天，
还有
对不起。
小姐，你还有其他的事情需要告诉我吗？就是指这位法官。
对的，我想说，昨天发生的事情是他一手设计的，他想陷害我，然后他想陷害我，对他有家暴情况，而且这个事情不是第一次，在今年的2月份。
稍微等一下。
好。
So, I want to talk about something about what happened yesterday. Your Honor, she gave me a lot of information. Should I keep going or?
Well, I don't need to hear about the facts. I have the facts in my file.
小姐，我现在不需要你讨论关于昨天发生的事情，我的档案里面有这些东西，我不需要你讲。
好的。
Okay.
All right. Thank you, ma'am.
Thank you.
谢谢。
All right. I'm going to set his bond at $500.
我将会把他的保释金设置为500块钱。
Now, sir, I want you listening to me. I don't want you talking to your attorney while I'm talking, okay? Your bond is $500. You're to have no contact with your ex-wife.
Could I,
Go ahead, Mr. Interpreter.
是那个保释金是500块钱，不可以跟前妻接触。
I want to make sure that the ex-wife is hearing what I'm ordering here, so she'll know.
could I plead that
Now, you're also to maintain a separate residence from your
然后呢，你
ex-wife. You can't go back to that house.
there are many
Sir, stop. Now, go ahead, Mr. Interpreter.
是 ，Thank you, Owner。然后呢，你不可以回到你这个原来居住的地方，需要保持分开的地方。Yes, Owner。
You are to consume no alcohol and no drugs not prescribed for you by your own doctor.
然后呢，你不可以饮酒，不可以使用任何的毒品、药品，除非是在有医生处方的情况下。
You are to have no weapons on or about your person, also as a condition of release.
同时，你释放的条件之一是身上不可以持有任何的武器。
Now, ma'am, was he, does he have personal stuff there at the house that he's going to need to get?
小姐，我想问一下，他本人有什么私人物品需要在你住的地方需要拿走吗？
对，他有很多他的东西都搬到我那了，对。
Yes, he has a lot of stuff. He moved into my place.
Then I'm going to let him come back one time in the company of a law enforcement officer to get his stuff out of your house.
那么在这种情况下，我将会给他一次机会，在有警察的陪同的情况下，回到这个地方，把他的个人物品拿走。
好的，谢谢。
Thank you.
So if he shows up and he doesn't have a police officer with him, you call 911.
如果他出现在你家里面，但是旁边没有警察的情况下，你要马上打电话给911。
好的，谢谢。
Thank you.
All right, thank you, ma'am.
Your Honor,
谢谢。
can I
have
represent
advised him.
myself today? And because there's so
Your Honor, if I
many-
may, I have advised him that the no contact order is up to the victim. He still wishes to have contact. However, I've advised him that's not going to change the situation. Additionally, Your Honor, he's saying that he wishes to represent himself. However, in 2022 CF 003138, there was a competency case. We were just asked to stay appointed and nothing further from the defense.
Oh, yeah, you're appointed. There's no question about that.
See, I'm the victim here. Am I allowed to speak for a few minutes, please, Your Honor?
Well, let me tell you something, Mr. Victim. If you go on speaking, there's a real good chance you're going to say something that could be used against you in a court of law. You've got a perfectly competent attorney standing right next to you who is giving you really good advice. But if you want to ramble on and risk getting yourself convicted, go right ahead.
I'm willing to risk.
Well, go ahead. You got about 2 minutes.
Of course, for the record, defense has advised him that speaking on the facts of the case is not a good idea today. It's not going to change anything, and he might
I think the
incriminate
record's
himself.
clear with that,
Thank you.
counsel.
Because there's so many, it's perjury, lying to the court. I did not lay a finger on her. And there's a court order that I have to reside there to comply with the court order.
That you have to
from
what?
Osceola County. There's a court order requiring me to reside at that address.
Now there's a court order that says if you try to reside there, you're coming back to jail.
No, there was an earlier court order from Osceola. There's a 2-year case. It's a trap played by my ex-wife and her boyfriends in order to trap me, to get my money, get my family into trouble. It was treachery. It was a long case, a series of cases.
See, now you want to represent yourself, and what you're trying to do right now is you're trying to try the case today. We're not here about the trial. You will eventually be able to do just exactly what you're doing. But today, the words are not going to change anything.
But I have borrowed money from my family. I have large financial positions. Whereas if I could not set up the computer, access my computer to cut off my losses and let my profit run, I could be hurt financially for a lot of
Oh,
money.
yeah, I suspect most people who get arrested are in some way or another harmed financially, loss of a job, loss of days at work, money they have to pay to post bond. Okay, so I understand all of that, but today is not the day to hear that. So this hearing is concluded. Thank you, sir. Well, good.
Can I say one last word?
Pardon me?
Can I say one last word?
No, sir. This hearing's over.
Can I,
The hearing is concluded, sir. Thank you.
The order stands even if you refuse to sign, just so you're aware. Contact our office when
Honor,
you're bond
I
out.
tell the ex-wife that the hearing is concluded.
Okay, you can explain all that to your attorney. Good luck with everything.
Oh, Mr. Interpreter, we are done. Thank you very much.
Sure. Thank you, Your Honor. You have a wonderful day. Take care. Bye-bye.
Hey, you too. You did a great job.
Thank you. My pleasure.
Okay, next up is Jamari Williams, or at least it's on top of my file.
Yeah. Seminole County.
Are you Mr. Williams?
Yes, sir.
Okay. You're being held on some out-of-county warrants out of Seminole County. Looks like some violation of probation warrants. Do you understand that?
Yes, sir.
And Seminole County has asked that you be held no bond until they come and pick you up. Understand?
Yes, sir.
All right. Any questions?
How many VOPs do I have?
There's 4.
4.
Yeah.
The same VOPs?
Well, I don't know exactly what they are. They don't necessarily send us that information. Just, it's a pickup. It's just grab your body and hold you until Seminole County comes to get you.
They'll tell you more there.
They'll probably be here today to get you. So before the sun sets today, you'll be back in glorious, well, at 5 Points out there in Seminole County.
Your Honor, it is possible not until Monday. It's 24 hours from the hearing, and it's about to be a weekend.
Well, now you're just making me
just
look
don't-
bad, counsel. Why
Your
are you
Honor, I
doing
just don't
that?
want him to get his hopes up back there and wonder
Have I
what's
done
happening.
something to offend you today that's going to have you making me look bad all day long?
So sorry, Your Honor.
That's all right. Thank you, Mr. Williams.
Good luck with everything.
Kenneth DeVilla. Why was this resent?
I couldn't
We
recall
waived his appearance yesterday.
myself, Your Honor.
Are you Mr. DeVilla?
No, sir. Richard Hall, sir.
Okay.
Mr. DeVille's hospital, sir.
Yeah, his appearance was waived yesterday.
Your Honor, the public defender's appointed. We can waive his initial appearance and,
Yeah, I actually showed that it was waived yesterday. But, okay, yeah. So he's being held on a charge of battery on a uniformed or licensed security officer. And again, I was mystified by the fact that somehow, no, correct. The bond on that is $2,500.
Had it
I read
listed.
the affidavit yesterday, found probable cause, so with that, moving right along.
I had it listed as 1,000, but I could,
It was 1,000, but it was corrected per the bond schedule by corrections to 2,500.
understood.
And the paperwork indicates that that's what I set it at yesterday. Am I correct?
25 was the original.
Yep,
Thank you.
okay. We got it. All right, Richard Lee Hall. Go ahead and state your name, sir.
Richard Lee Hall, sir.
All right, Mr. Hall, you are being held pursuant to a warrant charging you with battery and also false imprisonment. Battery, misdemeanor battery, felony on the false imprisonment. Do you understand those charges?
Yes, sir, I do.
Now, the warrant was signed by Judge Jewett downtown, who found probable cause. What we're here today about is talking about conditions of release. As to the, getting you an attorney, I have an affidavit that says you qualify for the public defender. Would you like for me to appoint the public defender to represent you?
Yes, sir, I would.
Okay. I'll do that at this time. So as to the false imprisonment, a bond on that will be set at $1,500. As to the battery charge, there will be an additional bond of $150. You're going to be ordered to have no contact with the victim or victims. You're to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person, sir.
Yes, sir.
Now, let me ask you this. Were you and the victim living together?
Yes, sir.
So ideally, you'd like to make one trip back to pick up your personal stuff, right?
Yes, Your Honor.
Okay, what I'll do is I'll authorize you to make that one trip in the company of a law enforcement officer to pick up your personal property only.
Yes, sir.
All right? Now, counsel, anything else?
I believe that's all, Your Honor.
All right? Mr. Hall, if you have any questions, you can ask your attorney.
Make sure you call.
Thank you very much.
You're welcome, sir. Step on up there, sir. What's your name?
Bobby King.
All right. Mr. King, you're charged with battery, and it's charged as a felony battery because it's alleged that there was some strangulation involved. Do you understand the charge?
Yes, sir.
All right. Now, I have an affidavit of insolvency here, but it indicates that you don't qualify for the public defender. So I'm going to appoint the public defender for just today.
Okay.
While you're here in court. And I suspect you'll be talking to a private attorney. I reviewed the affidavit, and I didn't seem to have a problem with probable cause. So I'll find at this time that probable cause does exist. Your bond is going to be set at $2,500. You're going to be ordered to have no contact with the victim. You're to maintain a separate residence from the victim.
He does
qualifies for
qualify.
PTR?
Yes, Your Honor.
That always amazes me. That a felony domestic battery would qualify.
Your Honor, he just told me that he would prefer to keep the bond instead of pretrial release.
Got it. So $2,500 on the bond, no contact with the victim, maintain a separate residence from the victim, consume no alcohol, no drugs not prescribed for you by your own physician, and have no weapons on or about your person. Now, Mr. King, is there any reason that you need to go back to the place where the victim lives?
That was my home, sir.
Okay, so the victim, while the victim is there, you can't go there.
There no one stays there but me.
And so the victim doesn't live there?
No, sir.
Okay, well, if that's the case, as long as there's no contact with the victim, you can go home, all right? So we clear?
Yes, sir.
All right, any questions you have, now would be a good time to ask the attorney.
Okay. Right now?
Yeah.
So I gotta call. Thank you.
Good luck.
You're welcome. Step up there, sir. Good morning.
Good morning, sir.
Tell me your name.
I'm fine.
Okay, Mr. Lyons.
Sir, Your Honor, I can very
Do we have the hearing?
can't hardly hear you, sir.
Okay.
Your Honor, we have a device for that. They're gonna grab it.
I've got earthings, and
They're grabbing it.
I've lost them, and the VA's getting me new ones. I apologize, sir.
It's all right.
Oh, it hasn't been working.
I'm supposed to go Monday to get the new ones.
The VA does hearing aids?
What do you say?
He said the VA does hearing aids. The VA does hearing aids.
Yes, ma'am. Yes, sir. I had a brand new set a month ago and lost one. They've ordered me another one. Okay.
Okay. How about it? Can you hear me now?
I can hear you a little better, yes.
Okay. It's like the telephone commercial.
Yes, sir.
Can you hear me now? Good morning.
Good morning.
Yep, I'm gonna need you to speak up a little bit.
Good morning.
Okay, there we go. All right, now, Mr. Lyons,
Yes, sir.
you are being held on charges of aggravated battery, which is a felony, and aggravated assault with a firearm, also a felony. Do you understand that? No, sir.
don't need
I
to-
don't want you talking to me other than answering my question.
He's just asking if you understand that those are the allegations against you.
I do understand.
Okay. Now, my job is to review this affidavit, this arrest affidavit, and determine if probable cause exists for those charges. I reviewed it. I found probable cause for each of the charges. Now, I have an just listen to me.
I apologize, Your Honor. He said he's having a hard time. Do we need to turn it up a little more?
It's as high as it can go.
It's as high as it-
It's as high as it can go.
I don't want His Honor to get upset at me.
Your Honor, he's still struggling to hear. I can always repeat what you're saying. It may come as an annoyance to the court, but if that's necessary, I can do it.
Well, I would never get annoyed at that. So
Hear me all through here.
can you hear me now?
Yes, sir.
Okay. The affidavit that you filed indicates that you qualify for the services of the public defender. That's the public defender standing right next to you.
Nice to meet you as well.
Do you want me to appoint the public defender as your attorney?
Yes, sir. I guess.
Okay, I'll do that. She's now your attorney, okay? Now, I'm going to talk to your wife over here.
May I say something to Your Honor first?
No, sir. I want you to talk to your attorney before you say anything out loud in this courtroom, okay? I know you think I'm being rude, but I'm trying to protect you. So, good morning, ma'am. Tell me your name.
My name is Linda Lyons.
All right, and the defendant is your husband, is that correct?
Yes, sir. 58 years.
I read how long?
58 years. And today's his birthday.
I read the affidavit, so I know what the facts of the case are.
Yes.
Let's talk about conditions of release. We'll start off with, I can order him not to come back to the house. What do you think about that?
If I could know that he wasn't losing his temper. I mean,
Which nobody can know.
Pardon me?
Nobody can know that.
I know. I don't want him to be away from me, but I don't want to get hurt.
Yeah.
So.
Does he have any place else he can go?
I really don't know. Probably a cousins or
friend,
something.
Relative?
He has a couple. But this is so hard.
Well, I understand, but we got to decide, because I've got to order one of two things. I've either got to order that he's to have no contact with you, or that he's got to have no hostile contact.
No
I've also got to order that he either gets to come home or he doesn't get to come home.
Well, I want him to come home, no hostility.
Yeah, well, what do you think the chances are that he's going to pay attention to that order?
I don't know. I hate that I even called the 911, but I was getting hurt, and I have a son
Right,
that we adopted,
right?
our
How old
grandson.
is your son?
He's 13. He's right out here.
All right.
And he's hard-headed, and my husband's hard-headed. That's not a good mix.
No, I agree. But, again, I want to stress to you that I can enter all the orders in the world, but if he's back there and under the same roof with you and he decides he wants to hurt you, those orders are not going to stop him.
I know.
So you have got to stand up and be brave about this. And I understand it's tough, but you got to realize that if you don't protect you and your 13-year-old son, nobody else is. So you want him to come home or not?
That's the hardest thing. If I want
I tell you
him
what,
to come home.
I'm going to take the pressure off of you.
Your
Okay?
Honor, and also as a state, I would just say, based on the facts of the case, that there was a firearm and the witnesses have both corroborated, I would ask that there is no contact at this time.
Oh, I'm already
that
going there.
And that he's not allowed to return to the home.
I'm already going there.
And Your Honor, I just want to inform the court that he's having a hard time hearing what's happening.
Right. Well, I'm going to turn around now and where the headphones go? They aren't?
I don't know if you're able to.
Well,
Would he allow me to purge?
There's nothing for you to hold either.
Would the judge allow me to?
yep.
I apologize, sir.
No, if he goes beyond that place he's at right now, I'll have to have him shot. You don't want me to do that.
Am I allowed?
He's going to talk to you. Yeah, sorry.
So, Mr. Lyons, can you hear me now?
I can hear you somewhat, sir.
Okay. I've got to order today, based on the hesitancy of the witness for her protection, that you are ordered to have no contact with your wife until further order of the court. You are to maintain a separate residence from your wife until further order of the court. You're to consume no alcohol and no drugs not prescribed for you by your own physician. And you're to have no weapons on or about your person. Now, any weapons that you own, guns in particular, you are ordered to turn over to the Orange County Sheriff's Department within 10 hours of your release, and they'll give you a receipt for them. Did you understand what I just said? Absolutely. Not now, you aren't. It's Florida law, sir. Once an injunction or a domestic violence case is pending against you, it's illegal for you to have guns anyway. So you've got to turn your guns into the sheriff's department. Now, they're all at home, no doubt. You didn't bring them to jail with you, right? Your guns are at the house, right? Your guns are at home, right? So what I'm going to do is suggest to your wife that she take all the guns and turn them over to the sheriff's department and get a receipt for them.
May I talk to him?
As long as it's not about the facts of the
How long will
case.
these be held?
Depends on how long the case is pending.
I'm sorry?
It depends on how long this case goes on.
Okay, well, most of the guns at my house are mine, but my boy, who's 13, I'm teaching him to hunt. He's got 3 or 4 guns of his own.
They're gonna get turned over too,
Okay,
so that you don't have access to them,
I wanted to make that straight.
okay?
What
Yeah.
I did yesterday was a cowardly act, sir.
And, Your Honor, I actually have a question. Did you give him a time limit on when to return the guns?
Yeah, within 10 hours of his release, unless his wife turns them in before that.
Your Honor, my concern with that is he has to first contact law enforcement and schedule an appointment at their availability to then be able to go back to the home to get his belongings, including those guns. So he may not be able to get that scheduled within the 10 hours. We would request longer than that so that there's no issues.
Ms. Lyons,
Some of those weapons
Yes, sir.
are collector's items.
can you gather up all the guns and turn them over to the sheriff's department?
There's a lot of guns,
Okay.
at least 30.
Your Honor, and again, with that, we would also ask for more time.
So, can you gather them up?
Yeah.
Put them in the trunk of your car and carry them to the sheriff's department and say he's ordered to turn them all in and you're doing it for him before because he
Yes.
can't come back to the house right now,
Okay.
all right? Now, I am gonna let him come back one time in the company of a law enforcement officer to pick up his personal stuff. And I'm gonna tell you why I'm doing this, because you clearly are frightened about him hurting you again. And, under the circumstances, sometimes the best way to get through to a person that behavior is not gonna be tolerated is to take away from them what they love.
Oh, yeah.
In this case, his home, his family life, his guns, even if it's just temporarily, to make them understand that behavior is not gonna be tolerated. Okay?
Yes, sir.
All right. So, having said all of that, I'm gonna conclude the hearing.
Your Honor, I don't know, what was the bond?
Oh, I don't think I actually
Yeah, I
said a
don't think
bond
that
amount,
was
did I?
set.
Well, I got all wrapped up in the other stuff. So on the aggravated battery, I'm looking at his income on this, public defender form. And, I don't want to add to these people's misery with a huge bond.
Thank you.
So on the ag battery, I'll set his bond at $1,000. On the aggravated assault, there will be an additional bond of $150 and all of the other conditions that I just ordered.
Yes, Your Honor, and just again, because of the Hardit hearing, I'm letting him know that you set bond of 1,000 on the first count and 150 on the second count for a total of 1,150. That's your bond.
You know, the VA has a facility out at Lake Nona
Yes.
where veterans can kind of hang their hat. I mean, they have conditions to do that. You might want to look into that, because does he go out to Lake Nona, or does he go
Yes.
over to?
He goes to Lake Nona.
Okay. All right. Yeah, you may want to look into that for
What
him.
kind of facility would,
It's really, what do they, I'm trying to remember what they call it.
I think it's a rehab facility.
Well, there is a rehab facility, but they have a name for it that's not rehab.
Assisted living?
They actually have an assisted living facility out there, but in my understanding is in order to be in that facility, a person has to be in the final stages of life.
yeah.
It's almost like hospice, you know? But
He
there's
just had a-
another facility out there.
I'll call him.
Yeah, give him a call and tell him what's going on. And, because he doesn't look like he's in real good shape physically anyway.
He just had a quadruple bypass.
Okay.
In February.
All right, call them up. They may be able to, because there's also one over at Lake Baldwin, or there used to be.
Yeah. So if he gets his bond out, when does he go to court? Or does he get bonded out after the court date?
No, today is the only thing he has to do before he can bond out. And then his next court date, we don't know what his next court date is, because first the state's got to make a charging decision as to whether or not they're going to file formal charges. And then it'll be assigned to a division downtown. And then from there, that division takes over and they do everything.
Okay.
And we have no way to access anything, because we don't know what division's going to be in.
So if he gets the bond, does he get out today?
Yeah, if he can bond today.
Okay. So he has someone else come do it? I'm not supposed to do it, am I?
Anybody can do it. And quite frankly, probably if we kept track of it, we would find out that the majority of times somebody bonds out on a domestic violence case, it's the victim that pays the bond. I'm not saying that's right,
I know.
but that's the way it works.
So do I need to see about that today?
That's up to you, man.
Here?
That's up to you.
Do I do it here?
Oh, yeah, down there on the first floor. Look, you're in a bad situation, I understand, and you know, maybe you've been through this before, maybe you haven't.
I've
but
never done this.
You got somebody else to protect in the deal. You got that 13-year-old sitting out there.
Yeah.
He's watching this, learning that's the way relationships work.
No.
So keep that in mind, okay?
I'll let him figure it out.
Good luck.
Thank you.
You're welcome.
Your Honor, for the next one, I do have a probable cause argument
You do?
for the strangulation portion only.
Let me look and see. Oh, there's somebody wrote PC right next to that on my thing here, see?
Look at that.
So, yeah, I'd already seen that. I think the argument is going to be that there's no indication that the person's breathing was restricted in any way?
Yes, Your Honor.
Okay. I probably owe you that much for giving you a hard time earlier. So, your name, sir?
Your Honor, my name's Ramon Guillermo Pena.
Mr. Pena, you are charged or being held on a charge of aggravated assault with a firearm, battery by strangulation, which elevates it to a felony, and then there's a simple battery count, misdemeanor, and unlawful discharge of a firearm. Do you understand those charges?
Yes, Your Honor, I do.
Okay. Now, you filled out an affidavit for us today that indicates that you qualify for the public defender. Would you like for me to appoint the public defender for you?
Well, Your Honor, if I would say yes.
Okay, then I'll go ahead and appoint the public defender. In reviewing the affidavit, I did find probable cause for the aggravated assault with a firearm. I did not find probable cause for the battery by strangulation, and I found probable cause for the simple battery, and then probable cause for the unlawful discharge of a firearm. So 3 of the charges, I did find probable cause for, the one I did not. Okay? You understand?
Yes, Your Honor, I understand.
One of the reasons we appoint the attorney at this point is so you have somebody to ask questions of if there's anything I say that you don't understand. All right? Now, we have no victims present out there, so nobody wants to talk to me about it. That means here in Florida, if you are familiar with the statutes, that I'm going to set some bonds for you and some conditions of release, okay?
Understand, Your Honor.
You need to pay real close attention to the conditions. I see that you are a veteran, just like the gentleman I saw before you. And, you know, there is such a thing as Veterans Court here in Orange County, which I should have talked to that young lady about that. And so you're going to want to talk to your attorney about possibly having the case sent over to Veterans Court. But as to the aggravated assault with a firearm, I'm going to set your bond at $2,500. As to the battery, I'll set an additional bond of $150, and the unlawful discharge of a firearm, $150. I'm going to ROR you on the battery by strangulation, finding no probable cause on that one. And you're going to be ordered to have no contact with the victim or victims. You are to maintain a separate residence from the victim or victims. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person. Now, my understanding in the affidavit is you were living there with your daughter, and I guess the boyfriend was kind of hanging out there too?
Well, Your Honor, my daughter has been living with me for 8 years, which I brought from Georgia because her mother.
That's all
Okay.
he needs to know.
And,
So you and your daughter live under the same roof?
Yes.
She's named as a victim here, so as long as she's under that roof, you can't be under that roof. Understand?
I understand, sir.
Okay. So no contact with the victim, maintain a separate residence from the victim, no alcohol, no drugs not prescribed by your own physician, no weapons on or about your person. And I'm going to order that you turn any weapons that you own or regularly have use on over to the sheriff's department within 10 hours of your release from jail.
And Your Honor, defense understands where the court is coming from, but similarly, one, we're going to request a one-time return to pick up belongings with law enforcement.
Yep.
Additionally, 10 hours is a pretty short window to schedule that return to be able to pick up those guns, and it would be no fault of his own if they weren't available within those 10 hours. We would request a longer length, at least 24 hours to.
So you seem to think they have to set up an appointment.
They
can't just walk into the sheriff's department over there on West Colonial and
It-
say, I've been ordered to turn these guns in?
Well, they need an appointment to go get, he needs to go back to the house first.
Ah, I see.
And he needs to schedule with them with the one-time return to make it to the house first.
So
to
if I
even-
made it within 10 hours of him being able to access the guns.
Defense would be
that
fine
work?
with that. Yes, that would solve it
I
all.
have to apologize. I didn't understand where you're coming from on that. Now I have a clear understanding.
With scheduling with law enforcement for the one-time return, it may take longer, is what I was getting at.
I see.
That was the concern.
So we'll make it within 10 hours of his being able to access the guns.
Yes, thank you, Your Honor.
Okay.
That solves it.
So, Mr. Pena, now if you have any questions you want to ask your attorney before you say it out loud here, okay?
And Your Honor, one other thing, just for the record, I know we've requested the one-time return with law enforcement, but I just want to make sure it's clear
Yeah,
that it was
Get
granted.
that on there. Give him that one-time return trip.
Law enforcement took all my weapons from my home.
If law enforcement took everything, you're
Yeah.
good, but you have to surrender any you do have.
They took it all?
Yeah, if they took it all already, then you're good. But any you have left. Right. And then call on. Schedule.
Thank
So what branch of the service were you in, Mr. Pena?
U.S. Army, Your Honor.
Army?
Yeah.
Okay, well, Semper Fi.
That's Marine, sir.
I know. Good luck.
Shoot the dirt with them too, sir.
You know, you can always recognize a
Good luck,
Marine
Your Honor.
by the obnoxiousness.
Your Honor, Van Dees Christopher, mental health.
He's what?
It seems like he has a victim here, and is that for this case? Yeah. If we can waive his appearance and if you appoint the public defender, Your Honor, get him a bond, hear from
Come
the
on,
victim.
come in the box. You said he's medical or refused? Mental health.
Mental health.
Okay, all right. Morning, what's your name?
My name's Howard Michael Van Dees.
Okay, I think you're the named victim in here.
I'm sorry, I'm hard of hearing also.
Oh, yeah, I haven't run into that yet. So that'd be the one thing I haven't tripped over, but I understand. You're the named victim in this paperwork.
Yes, Your Honor.
Okay? We don't have him here, and I'm gonna have to get him here because he's gonna be held no bond until I can get him in front of me. And, or get him, in front of the court.
Can we waive his appearance to get a bond on the case?
Nope. It's domestic, ain't happening. Well, it makes it sound like I'm just being a horse's ass, but, he has to appear. That's why he's held no bond. So he's no bond until he can come here or until the court can make a separate determination that he's incompetent.
And I apologize, Your Honor, I thought hearing from the victim was enough to set a bond.
Yeah, no. Okay, so, I'm tempted to have you tell me what you'd like to see me order in terms of conditions of release, but I'm probably not gonna be the judge that he's brought back in front of.
Okay.
So your best bet would be to, if you want to be heard by the court,
Yes,
would be to come back when this thing is rescheduled.
I can do that. I just hope that he gets some mental health help.
Yeah, sounds like he needs it. So how are we gonna make sure that this victim gets notified? Can you put a note somewhere in the file, State?
Your Honor, defense is
I
gonna.
can, we can reset it till Monday also to see if he's available for. the
Your
hearing on
Honor,
Monday.
I apologize. Defense is going to again request if we can waive his appearance and get him on bond. Once they've heard from the victim and once conditions of release have been set by the initial appearance judge, he'll be notified of all those conditions of release before bonding out, and he'll be made aware of them. We would also be appointed as his attorney to represent him and to better advise him.
I'll be more than happy to appoint you as his attorney at this point, but I'm just not comfortable with waiving the appearance on this particular kind of charge.
Understood. We would just ask to reset to tomorrow then. There's no reason to hold him till Monday.
Sure, okay. Yeah, I can do that.
It
I won't be here.
would, and to spare, I don't know if to spare the victim time, if we can take the victim's testimony on whether they wish to have contact or not, or if Your Honor just wants to roll it all.
Well, did you hear that?
Yes.
So, obviously you want to see him get some assistance with the mental issues.
Yeah, I
Does he live there at your house?
no, he does not reside with me.
So if I leave it no contact between the two of you, you good with that?
Yes.
Okay. So we'll reset it for tomorrow, and then we'll just make a note somewhere on the file that the victim was present today
Okay.
and wants no contact with the defendant, okay?
Yes.
All right. Anything else?
No.
That'll do it?
Yes, Your Honor.
Okay, good luck.
Thank
Thanks
you.
for coming. So how about that, counsel? That work for you?
Your Honor, that will be acceptable, though defense would prefer that a bond was placed today.
Well, he's got a bond on the criminal mischief and the trespass. So part of your wish is granted.
Thank you, Your Honor.
Your Honor, Vasquez Jose, mental health.
Mental health. Okay.
Your Honor.
You would agree that the court has to concur
If we
with
can reset
waiving
this to
anybody's
tomorrow.
appearance,
If we
right?
if we can reset this to tomorrow, Your Honor.
No? Do you agree
Sorry, I apologize. What was the
that the
question?
court can accept or not a waiver of somebody's appearance?
Your Honor, that is fair.
Okay,
I do agree.
all right. Yeah, we'll have to reset Mr. Vasquez for tomorrow due to issues beyond our control. All right, step on up there, sir. What's your name?
Jason Willoughby.
All right, Mr. Willoughby. Huh? Not yet. No, we'll wait till he comes in tomorrow. All right, pursuant to a warrant that was signed, probable cause was found, you've been, are being charged with aggravated assault with a weapon as an incident of domestic violence and battery. Now, the ag assault is a felony, the battery is a misdemeanor. Do you understand?
Yes, sir.
Okay. And there is a warrant, and the affidavit, which the court who signed the warrant reviewed and found probable cause for those charges. In an abundance of caution, I reviewed it this morning myself too. Now, it looks like you qualify for the public defender. Would you like to have me appoint the public defender to represent you?
Yes, sir.
All right, so I'm appointing the public defender at this time. Now, good morning, ma'am.
Good morning, sir.
You're gonna need to speak up.
Good morning, sir.
There you go, thank you. What's your name?
This Shayla Willoughby.
Okay. Ms. Willoughby, you are the named victim here,
Yes, sir.
okay? So, you've been sitting out there long enough. It's kind of been crazy in here this morning, sort of a dog and pony show, but, just you and me are gonna talk now, okay?
Yes.
Tell me what you would like to see me do as far as conditions of release are concerned.
Yes, sir. I don't want to seem as if I'm excusing my husband's actions. He definitely has some things to work on. I think that he has been very stressed. We recently lost our baby, and we are on the verge of losing our home. And because due to me losing our baby and being sick, he's our only financial stability. We have 2 sons that are with us. And he has recently, this week, the incident happened Monday. Wednesday, he started anger management counseling and BIP, which is a batterers program. I would
say
like for
he
him.
started
Yes, he started.
the batter's intervention program?
Yes, sir.
Is that because there was an injunction?
No, sir.
DCF.
He just doing it voluntarily?
Yes, sir.
Oh, well, that says a lot about him.
I think that
So what do you want me to do? You want me to set a bond and conditions of release, right?
yes, sir. I would
Okay.
like for him to come home.
So
You know,
you
we
want him
don't
to
have
come back
much.
to the
We're
house.
trying. But the longer he's in here, the more that myself, and his children are kind of suffering without.
Right, but you want him to come home.
Yes, sir.
So what you want me to do is to give him a bond, order that there be no hostile contact between the two of you.
Yes, sir.
And then the other stuff, you know, no drugs and alcohol, no weapons, that sort of thing.
Yes,
Let
sir.
him come home.
Yes, sir.
Okay. Well.
I have some questions, Your Honor.
Yeah, go ahead.
Hi, Ms. Wolby. Is there a pending DCF action right now?
Yes, ma'am.
And is he under a case plan?
Yes, ma'am.
Are you guys allowed to reside together in your DCF case plan?
Yes, ma'am.
And so is he doing the batter's intervention under the DCF case plan?
It's voluntary. The anger management is under the case plan, but the other thing is voluntary. He chose to do that.
Okay, so there is a voluntary case plan in place.
Yes, ma'am.
Okay, so I would just ask whatever conditions Your Honor puts in place also to cooperate with DCF's case plan.
Sure. Okay. Counsel, did you need to be heard on that?
No, Your Honor.
Okay. Well, then, let's do the following. He doesn't qualify, well, wait a second, let me see. Maybe he does. No. Well, that's not the right one. Yeah, no indication that he qualifies, although he did score 0. Is that because of the nature of the charge that he's not qualifying?
Yes, Your Honor.
Okay. Well, then I'll set his bond at $1,000 on the aggravated assault, and then there'll be an additional bond of $150 on the battery. Now, Mr. Willoughby, I'm going to order that you have no hostile contact with Mrs. Willoughby. Means no arguing, no fighting, none of that stuff. Got it?
Yes, sir.
But that means you can go home when you get out of jail. I don't want you consuming any alcohol or drugs, not prescribed for you by your own physician, and you're to have no weapons on or about your person. I also am going to order you to comply with and cooperate with that voluntary plan that's been placed by DCF. You understand?
Yes, sir.
The batter's intervention program that you started, you've been what, to one class?
2 sessions, Your Honor.
Huh?
2 sessions, Your Honor.
2 sessions.
2? Okay. Well, it's a program that people wind up in when they get charged with domestic battery, if, you know, down the road when the court starts sentencing. So my recommendation to you is you stick with it. You can learn a lot from it, and especially if you're there voluntarily. I've sat through those classes myself, and in the beginning it's difficult because you're giving up the time and the effort, and basically, you know, that's a lot of talk to you about, you know, how wrong you are and how to right yourself, and that's not something people generally take voluntarily, but so pay attention to it. So you understand what I'm ordering here?
Yes, sir.
Okay. And do you understand all of that, ma'am?
Yes, sir.
So he can get out today, and I do apologize for putting any more financial pressure on you all. I realize that's a part of the issue here, and but you know, got to do what we got to do.
Yes, sir.
So, any questions?
No, sir.
All right. All right. Then thank you and good luck.
Thank you.
Good morning, sir. What's your name?
Brian Godino.
Okay. Brian Munoz, eh?
Yeah.
All right. You're charged with battery. It's alleged to be an incident of domestic violence. Do you understand the charge?
Yes, sir.
All right. Yeah. I do find probable cause for it. And so, looks like you qualify for the PD. Would you like for me to appoint them for you? The public defender?
Yeah.
Okay, I'll do that. And set your bond at $500. You're gonna be ordered to have no contact with the victim. You're to maintain a separate residence from the victim. You're to consume no alcohol, no drugs not prescribed for you by your own physician. You're to have no weapons on or about your person, sir.
And Your Honor, I believe we'll need a one-time return to pick up personal belongings with the presence of law enforcement.
And I will authorize you to go back to the property one time in the company of a law enforcement officer to recover your personal effects.
Yeah.
All right?
All right. No question.
You got that look on your face like you're expecting something more.
When I pay, can I go back?
Huh?
Once I pay the bond, can I go back?
To the house?
Not if he's
Yeah.
living
No.
there.
Never?
Yeah, yeah, theoretically, never.
Not if he's living there. You cannot, unless you call law enforcement and schedule an appointment to
But
pick
he
your
didn't
belongings.
understand anything.
As long as this case is pending, as long as this order's pending.
I'm sorry.
Well, I could tell by the look on his face that he wasn't comprehending what was
As long as
going
this
on.
order is pending, you'll have to talk to your attorney about modifying it, okay? Don't talk to your dad. Okay?
All right.
If you go back to the property without the law enforcement, you come back to jail,
We're gonna
sir.
arrest you, so that's, yeah.
You don't want
go
that.
back without law enforcement.
All right, Mr. Jackson, how are you?
I'm good.
All right. Let's see, got anybody? Nope, nobody over there. You're charged with battery and assault. Two separate charges, both misdemeanors, both alleged to be domestic in nature. Do you understand that?
Yes, sir.
Okay. Now, you didn't fill out an affidavit of insolvency for me, so I guess you're gonna talk to a private lawyer?
Fill out what?
Affidavit of insolvency. It's a PD affidavit.
Who do I talk to?
Were you seen by the social workers in the back? You didn't speak with the social workers in the back? Your Honor, he didn't have an opportunity to speak with the social workers in the back to fill out the affidavit of insolvency. There are situations where they're either in another cell or not brought up or
Right.
sometimes not seen.
Well, okay, then, he qualifies for PTR too. So,
I wasn't asked.
do you work?
Yes, sir.
What would you say your average paycheck is weekly?
Depending on the hours and the day, like I can make 40 hours a week.
Okay, let's assume 40 hours a week. What would you bring home at 40 hours a week?
After taxes, like 700.
Okay, do you support anybody other than yourself?
Yeah, I have
You don't have to go so close, has a little back. You can get, yeah.
I support 2 kids.
Okay, so you have two dependents.
Yeah, well, one is my official kid and the other one is like my stepson.
Yeah, but they're still,
Both my kids.
you support both of them.
Yeah.
So $700 with 2 dependents, he'd qualify. Okay, I'll go ahead and qualify him and appoint the public defender. Now, you also qualify for what's called pretrial release,
Yes, sir.
which is a non-monetary form of release. You don't have to post a bond, but there are rules associated with it that will be explained to you before you go.
Yes, sir.
All right, you got to comply with those rules or else you wind up back here.
Yes, sir.
All right, so we do that. I don't have a victim here today. So I'm gonna have to order that you have no contact with the victim as a condition of release.
I'm completely fine with no contact with her.
All right. Maintain a separate residence from the victim, can't live in the same place.
Completely fine with that.
No drugs, no alcohol, and no weapons on or about your person as a condition of release. Understand that?
Yes, sir.
Okay. So, any questions you have, you want to direct them to your attorney.
At a point in time, we was. Nah, because she moved, so everything is at my. Quick. Who would I go through it about my kids?
What do you mean?
Your Honor, may we have third-party contact for child care purposes only?
Yeah.
What does that mean?
They have a child in common for purposes of taking care of the child. Sometimes they allow third-party contact, meaning he can contact a mom, a friend, to organize the child care.
See now, no. And I don't think I've adequately explained that to you this week, and I should have stopped at some point and explained it to you. We have no way of knowing what the victim wants because we don't have a victim here. You know, if we had a victim here, potentially, if the court were willing to take the time, we could work something out. But there are certain inquiries that have to be made about the whole situation before I start ordering anything regarding the children.
Understood.
So under the circumstances, I'm just not comfortable with that. And so that's something that, you know, I don't know what to tell people about that other than, are you married to the person that you have this child with?
Sure.
Has there ever been a paternity case? See, that starts number one. He has no rights with that child. Legally speaking, he has no rights. It's not been determined that he is in fact the father. So if I start ordering stuff like that, I might as well be ordering it with him and the neighbor's kid. So it's just too complicated.
I understand, Your Honor.
Okay. Good luck, sir.
So there won't be no.
I really need a gigantic stiff drink this morning. Something
This morning.
with an umbrella in it, possibly.
Thank you.
You think?
Pineapple.
Olive, something. Yeah, right. Okay. Good morning. What's your name?
Jessica Jenna Jofield.
Okay. You pronounce that Joe Field, right? Okay. Well, Ms. Joe Field, you're charged with battery. It's alleged to be a domestic battery because of the relationship between yourself and the victim.
Yes.
And I reviewed the affidavit. I did find probable cause in there for the charge. You also qualify for the public defender. Would you like for me to appoint the public defender for you?
Yes.
I will do that. The public defender is now your attorney. And what's your name, sir?
Hugh Ferguson.
I'm gonna have to speak up a little bit.
Hugh Ferguson. Hugh Ferguson.
Okay, Hugh
Ferguson.
Yep, there it is. Hugh Ferguson Jr., right?
Yes, sir.
Okay. You're the victim, Mr. Ferguson.
Yes, sir.
What do you want me to do? I don't want to put you on the spot, but I'll just ask you some questions. That'll help.
Okay.
Y'all were living together, right?
Yes, sir.
Okay. Do you want her to come back?
No, sir.
Okay. So order her to stay away.
I don't want to add that to her. I think she understands how I feel, and I think she will stay away on her own. So I don't need that order. Initially, I was going to come here, and which is why I'm here. I actually took off to come here for the injunction, but we understand each other. We won't go into the particulars of the case, but after my last few days concerning this matter, I think she's going to have enough on her plate. This is costing her a job. Her boss, Daniel, don't want her back. The ex-husband don't want her there. All of her, there's no reason for me to have contact with her. All of her belongings have been taken back to where I picked her up at her grandma's. So no one else would take them.
So she has no reason to come back
She has
here
no
because
reason.
you've taken all her stuff to her grandmother's?
Everything.
Okay.
Another reason I'm here, again, I kind of got to talk about the facts. I own a moving company, so I'm out of town. I'm always on the road. I'm always on the go. In my absence, she was having drug dealers come to my house, sex in my house, okay? And they have my address. So if I have to give any directive to this court, it would be that, one, first of all, Ricky Sloan, which has been not just to my address here, but my previous address via her text mails, her videos, her photos in my home with this guy. So if this drug dealer accosts me in any way concerning her, we have a problem, or my home. This is what was going on. This is where we are. So again, I don't need an order from her. She may need an order from me, to stay away from me, stay away from my home, my business, or anything. She has a drug problem. I take her daily to the Longwood opioid center for meds daily. I have done everything to try to straighten out what's going on with her. Okay, so apparently it's not working. Okay, so I've already talked to her counselor, Miss Evie, over at the Longwood Comprehensive Center. So they'll go from there. They'll deal with that portion of it.
Okay, do you understand that once I order her to have no contact with you,
That I can't have any contact with anything. Yeah, that's not a problem, not an issue at all.
well, I
Or
order
anybody
that.
concerning her.
If she violates that, you have to call the police.
I will.
There's no
I called them
automatic.
twice this time.
Okay?
I just
All right.
wanted her to go. When you caught, you caught. When it's over, it's over. When it's done, it's done.
Sounds like it. Okay, got it.
So like I say, you can order no contact. I'm not requesting it. I don't really care.
Well, if you're ambivalent about it, and believe me, you're ambivalent about it, like that young lady or the lady I had in there earlier who was, like on both sides of it. She didn't want it, but she felt like she needed it. She was
Yes, sir.
scared, but she didn't want him not to have a home. That's called ambivalence.
Actually,
And if you're ambivalent about it, it becomes no contact.
right.
Okay?
Right.
So that's where I'm going.
Well, yeah. Well, if that's what's necessary, if that's the way the system,
All right,
goes, then I'm fine with that.
all right.
Um,
Sir, I'm gonna have to cut you off. I
Okay,
gotta
that's fine.
move on.
yeah.
It's taking me forever to
But
get.
she has no reason to come back to my home.
All right,
She has
got it.
nothing there.
Okay, so yeah, finding probable cause, bond is gonna be set at $500. Now, you're gonna be ordered to have no contact with Mr. Ferguson. You are to maintain a separate residence from Mr. Ferguson. You're to consume no alcohol, no drugs not prescribed for you by your own physician, or possibly, it sounds like there may be methadone involved in your life. I'm not talking about the methadone. Methadone, as long as you're getting it through the clinic.
Fentanyl is her drug of choice, according to her counselor.
Huh?
Fentanyl is a drug of choice, according to her counselor,
Okay, and,
which I was not aware
you're
of.
also to have no weapons on or about your person as a condition of release. Understand? Use your voice.
He wants to know if you understand what you're.
Yes.
Okay, so any questions that you have, you want to talk to your attorney about them and run them by your attorney before you say them out loud here in court, okay? Good luck.
Thank you.
Oh, yeah, do not return, yes. Good night, this is taking forever today, isn't it? Well, again, it's one of those days where you just say, no matter how much I whip the horse, it's only gonna go at the speed it wants to go at. So, and I got horses on my mind this morning. So, good morning, what's your name?
Oh, Cassandra Seguinot.
Okay, how do you pronounce that?
Seguinot.
Okay, Seganot,
Yeah.
just like it's spelled. You're charged with battery, and it's alleged to be domestic in nature. Do you understand that?
Yes, sir.
Yep. I reviewed the affidavit. I do find probable cause for the charge, and I see that you qualify for the public defender. Would you like for me to appoint the public defender for you? So I'll go ahead and do that as well. And so that's your attorney now. What's your name, sir?
Leandre Best.
I see. Bess, right?
Yes, sir.
Okay. I can see your lips moving, but I can't hear you.
Yes, sir.
All right, thank you. Okay, so this young lady is, according to this, your girlfriend,
Yes, sir.
and you guys were living together?
Yes, sir.
So what would you like to see me order today, Mr. Bess?
Honestly, sir, we were just under like a lot of stress, and I just want her to come home and,
You feel safe having her come back to the house?
yes, it's never really no issues like this at
She
all.
also qualifies for a non-monetary form of release called pretrial release. Do you have any problem with me letting her go that way?
I mean, I can let her, whatever is best, but if you can post a bond, whatever, I can pay the
Well, I
bond.
understand, but if there's a way for her to get out of here without having to post a bond, are you okay with that?
Yes, I'm okay with that.
Okay, and you just want her to come home?
Yes, come home, we can have.
I'm not gonna order her to come home, but, because I don't know what she's thinking. She may decide she wants to go someplace else.
Yeah, that's.
But what I'm gonna say, I'm not gonna order her not to come home, okay? All right, anything else?
No, sir.
Good, thank you.
Okay.
So, yeah, PTR, you qualify for that. So I'll authorize your release, PTR. And, there are rules, they're gonna explain them to you, you'll have to comply with those rules. And the rules pretty much are gonna be the same rules I'm about to put on you, with some others. And that would be, there's to be no hostile contact between yourself and Mr. Best. No more arguing, no more fighting. If there's arguing and fighting, you gotta go. Because otherwise, police show up, you come back to jail. No alcohol, no drugs, not prescribed for you by your own physician. No weapons on or about your person. Now, any questions you have, talk to that very intelligent attorney right next to you there.
She has no other questions. Thank you, Your Honor. Contact.
Good luck to you, Ms. Seganov. Moving right along. What's your name, sir?
Jean Francois.
Mr. Francois. Got some out-of-county warrants, sir. Looks like they're out of Polk County. One has a $5,000 bond, one has a $1,000 bond, and then there's also PTR associated with the one that has the $1,000 bond. Do you understand that?
Yes, sir.
Okay. And of course, you're out on bond on some stuff up here as well. There's really no reason for me to do anything with those cases that you're out on bond on, so no action on those. But you understand you can post bond on the Polk County cases.
Okay.
Because you have bonds, or you can just wait for Polk County to come and get you.
Okay.
All right? Good luck.
Probably by, I would assume, Monday or Tuesday, okay? Good luck with everything.
Okay, how about, I have Ruben Rivera. Step on up there, Mr. Rivera. You've got an out-of-county warrant, and I believe it's also out of Polk County. Yep, it is. Unfortunately, in your out-of-county warrant, they've ordered you held no bond. Do you understand?
Yes, sir.
Okay. So, if you have questions, I can try to answer them, but chances are I won't know the answer.
Yes. That Polk County, it was all resolved here. That was back in 2020, I think. but
It was resolved here?
it was all resolved here. I never traveled to Polk County in that time, so I don't know.
Says here you're on state probation.
Your Honor, I'm not positive what happened, but it is possible that he resolved the case in one location and supervision got moved to the other. I don't know if that's causing the confusion.
Yeah, I'm sorry.
No, it's fine.
I'm not sure why you're telling me that.
Yeah.
Because it says here there's an outstanding warrant for you in Polk County.
Yeah.
So one way or the other, you gotta resolve it. You can wait here till they come and get you. You can call over there and get a lawyer or somebody to look into it for you. But, there's no way for me to confirm anything other than just to tell you that the warrant is there, okay? So, off to Polk County with you.
Okay. Good luck with everything. They'll tell you more
They
information.
used to call Polk County Imperial Polk County. Really, like they had a king over there or something. Did you say Charmaine Ross refused? Okay.
We can waive
It's-
his appearance.
Yeah, it's out of county warrant. This one's out of, let me guess where this one's out of. Osceola County, and it's a no bond warrant, so what the heck? We'll, let it go. Yeah, okay. And, let's see, Joseph Series. You're you got a number of warrants out of, Brevard County. Let's see, no bond. No bond, no bond, everything's no bond. That includes a violation of protection order. So, do you understand all that?
Sure.
Okay, and, Brevard County is on our list of they gotta be here within 24 hours, but there's a weekend, and so the weekend don't count.
Monday.
So it may be Monday. Maybe they'll come get you today.
Yes, sir.
All right, good luck.
You
Good luck
too.
with everything.
You too.
Let's see, what's your name, sir?
Richard Tolles.
Did you say Tolles, Richard Allen Tolles?
Sir.
All right. Really? This is a warrant out of Seminole County, I guess on a petty theft charge. There is a $500 bond.
It's already paid.
Huh?
I said it's already paid.
I see your lips moving, but I can't hear you.
The bond was already paid for me.
Oh, it is? So you just getting ready to get on up out of here?
If I could, yeah.
Huh?
I said if I could, yeah.
Well, unless you're being held on something else. But as far as Seminole County is concerned, you're ready to go. Good luck, sir.
He's
Thank you.
Good luck with everything.
Huh?
Out on bond.
He's out on bond. On two cases.
Yeah, no action.
This is an out-of-county warrant. We
On
don't.
both cases.
Let's see, you must be Mr. Horton.
Sir.
You're being held on a violation of community control, and it looks like the violation is failure to comply with your curfew hours. That's what it says on this paper here. And that paper signed by the judge over there in felony wants you held no bond pending further order of that court. Do you understand? All right. And it looks like you qualify for the public defender, so why don't I go ahead and appoint them for you?
Okay, thank you.
All right, I'll do that, and then you'll probably be seen in courtroom 3 next week.
Thank you.
Good luck.
I printed this out for you. I don't know if you received.
Let's see, step on up there, sir. What's your name?
Jonathan Elijah Jefferson Miller.
All right, Mr. Miller, you got new charges. You got a fleeing and eluding and a no valid driver's license charge.
Yes, sir.
I did review the paperwork, the affidavit. I do find probable cause for those charges. On the fleeing and eluding, I'll set your bond at $2,500. On the no valid driver's license, stay it at $100. And looks like you qualify for the public defender. Would you like for me to appoint them for you as your attorney?
Yes, sir.
Okay, I'll appoint the public defender for both the new charges and the VOP. You got a on-view violation of probation that's been filed because, let's see, yep. Looks like you're on probation, active felony probation. So you'll be held no bond on the on-view.
Using the new laws to violate your probation.
Pending further order of the court where that's pending, which means there's probably a warrant coming through as we speak. And hopefully you'll be seen in courtroom 3 next week.
Okay. So he was saying the warrant for the violation of probation should be probably coming through the new laws or what, it was an on-view because of the new laws, you've been on probation, they violated you. So you have no bond on that, talk to your attorney. You appoint the public defenders on both, and then you do have bond on the new cases, on both counts, okay? Or on the new case. Okay. Good luck with everything.
Good luck, sir. Good morning, sir. What's your name?
Jamar Lee John.
All right, Mr. John, you're being held on, what do we got here? 1, 2, 3, 4, 5 counts of possession of a firearm by a convicted delinquent. And you're 20 years old,
Yes, sir.
right? Interesting.
And Your Honor, regarding the possession of a firearm by a convicted delinquent, defense is unsure if the case number or the delinquency was actually mentioned in the police report. We would just want to confirm that to clarify that probable cause is there.
I think they have the case number, and that he had just come from.
Did you not read it?
Your Honor, I did read it, but now that I'm thinking back, I'm worried if I missed it.
No, they did.
Okay, I apologize.
Okay.
Yes, Your Honor.
So, yeah, well, you do have some bonds on all that stuff. And $5,000 is to count 1, $150 each is to counts 2, 3, 4, and 5. And probably shouldn't surprise you too much that I'm also going to order that you're to have no weapons on or about your person as a condition of release. Then you got an on-view violation of probation that's been filed along with those charges. So you'll be held no bond on the on-view violation of probation. And you qualify for the public defender, so I'll appoint them for both cases. Understand?
Sir.
All right. Good luck to you, sir.
As far as I know, it's regarding.
So, just so we're staying honest with one another.
I'll explain more.
Let's see, you Mr. Jones?
Sir.
Mr. Jones, you're being held on a violation of probation. It says, this seems to be a pretty common violation that comes through here. It says you didn't comply with your curfew hours.
Yes, sir.
And so the court over there decided to issue a warrant was the right thing to do and to order you held no bond for a curfew violation. So, you understand that?
Yes, sir.
I don't see an affidavit of insolvency in here. Do you intend to talk to a private attorney on this?
Yes, sir.
Okay, you see, you got a private attorney?
Yes, sir.
Okay. Well, good luck.
Okay.
And if you want to take this with you, you can take this. This is your warrant. I just want to make sure I got all of yours. Good luck.
Good morning, sir. What's your name?
Joselito Martinez Gonzalez.
Mr. Gonzalez. Didn't I see you yesterday?
Yes, sir. I think this is for violation today.
Yeah. This is VOP, which you already knew. And I'm going to guess it's an on-view violation of probation, so you'll be held no bond on that. I appointed the PD for you yesterday, so I'll appoint the PD for you on this violation as well.
Thank you, Your Honor.
Any questions?
No, Your Honor.
Good luck.
Thank you, sir.
Hi, good morning, sir.
Morning.
Your name is
Andrew R. Newman.
Newman? Andrew Newman. Mr. Newman, you're being held on a violation of probation. Says here you failed to report to probation when you were supposed to, and changed your residence without the consent of your probation officer. Judge Craner has ordered that you be held no bond on the VOP. Wait, there's some more. Failed to make restitution, failed to undergo a mental health evaluation. So, do you understand the violations?
Yes, Your Honor.
Understand that you're being held no bond on that?
Yes, Your Honor.
Okay, any questions you have? Well, I don't see an affidavit in here. Do you have a private attorney, sir?
No, Your Honor.
Would you like to have the PD appointed?
Yes, that would be great.
You got him. Good luck.
This is our phone number. Give us a call. You can also jail mail us because you're being held no bond right now. We'll contact you as well, too, okay?
Okay.
And then please do this
Here we go.
David. Right,
That guy looks like a vampire.
you can go that way.
Big time. I'll check with the PD and see if he had his sharp teeth. I'll ask a question later. What's your name, sir?
Vince Craig Rogers.
Mr. Rogers? Mr. Rogers. You're charged with possession of MDMA ecstasy, also known as ecstasy, and possession of drug paraphernalia. Do you understand those charges?
Yes, sir.
All right. I reviewed the affidavit. I do find probable cause. Bond is going to be, I'll stay the bond on count 1 at 1,000. I'll modify the bond on count 2 from 500 to 100. And then there's also an on-view violation of probation been filed. And I'll order you held no bond on the on-view violation of probation. Looks like you qualify for the public defender. I'll appoint them for you in both instances, okay?
Yes, sir.
Good luck, sir. Medical on Williams. Got it. Okay, we'll have to.
For Williams, Your Honor, if you appoint the public defender, we can waive his appearance.
Okay, so, he's charged with arson, and, that's pursuant to a warrant where probable cause was found. He doesn't have a bond on that, but I'll go ahead and set a bond for
Thank
him
you.
at, $2,500. And then he has a violation of probation. The bond is $1,000 on that. Shock of shocks. It's a felony probation, too. Failed to successfully complete 100 hours of community service is the violation. So I'll stay that bond at $1,000.
Thank you, Your Honor.
Oh, you're welcome. Okay, you got some 33-day motions, State. How about Ashley Tremue?
Your Honor, the state has filed on that case. We ask the motion to be denied.
All right, denied. And Pablo Luis Camacho Reyes.
Your Honor, the state has filed no information for this case.
Granted. And Keith Rashad Terry.
Your Honor, the state has filed on that case. We ask for the motion be denied.
Denied. Brandon Alexander Giles.
The state has not filed on that case, Your Honor.
That's granted. Terrell Ross O'Donnell.
The state has not filed on that case.
And that will be granted. Yuritsa Flores Morales.
Your Honor, the state has filed no information for that case.
All right, granted. Rashawn Francis.
Your Honor, the attorney stated that the motion is premature. Filing decision will be made today. 33rd date is not until July 23rd.
Yeah, I see that.
Your Honor, does the order reflect that as the correct date?
Does.
Sometimes it'll say to be released on their 33rd day of,
It says 7/23.
okay. No issue then.
So we don't need to trash that one.
And that was which one?
For another. Well, because I signed it and dated it today. I just jumped the gun on that one, so we can maybe print it out again? Okay.
Yes, sir.
All right, Brandon J. Marcus.
Your Honor, the state has not filed on that case.
So granted. And Anthony Marquez Etheridge.
I like that you could pronounce all the names. The state has not filed on that case.
I enjoy a challenge with some of the names, but saying the whole name is kind of cool, I think. Sort of respectful, too. I call all my children by all their full names. There's no such thing as nicknames at my house, unless your full name is a nickname. So what do we got? Jesus Yai. Or Jesus Yai.
The state has not filed on that case either, Your Honor.
All right. Okay. And how about Lucas Marquise Bowers?
The state has not filed on that case.
All right. George Quinones Santiago.
The state has not filed on that case, Your Honor.
All right. That'll be granted. And Jesus Manuel Ramos Diaz.
The state has not filed on the case.
All right. So, being as how the morning just sort of did what it did, I guess we'll come back at 1 o'clock.